for restoration of tram services in Kolkata. My lord has directed to fix those matters on 28th February. My lord, it is my new bill matter. My lord, kindly.
Tomorrow it will be listed automatically.
Tomorrow will be hard.
You give the number.
My lord, I want to heard the matter on 28th.
No. Fresh motion will come tomorrow.
Yes, tomorrow.
Then we will pass it on.
Yes, sir.
My lord, I'm praying for leave to file one appeal without certified copy.
Date of the order?
My lord, this is of this month, my lord, 17th of this month. I have applied for the certified copy, my lord. My lord.
Yes,
Lord, regarding contempt application, the appeal matter.
Appeal, my lord. Appellant is 90 years old, doctor. Actually, my lord, can remember that the development agreement in Salt Lake, he was a lessee under the government. Naturally,
it is running in the monthly list.
No, just appeal file against the single bench order appeal.
Fresh
My
case.
lord, 90 years old, my lord, that is.
My lord, may I be permitted to mention one original side matter, my lord? It's a group 4 matter I am mentioning upon notice. It's a review application, my lord. It's a order is on for 9th May 2024. Which passed by Honorable Justice Surya Prakash Keshavani and Justice Rajashree Bharadwaj. Now this court has the determination, my lord. So
No. Review will come before the division bench headed by Justice Rajashree Bharadwaj and some other judge. You give a letter to the OSD, I will place the matter. Please call.
May I permit to mention, Lordship, item 6, Lordship.
Item 6.
Item 6, Lordship, by chance mistake, Lordship, attached 27, but my mat is mat 57, 57 or 25, Lordship.
No.
Two appeal I filed, one from the review application, one from the original order.
No. Can you mention? No. Can you mention when the matter reaches? Because.
Yes, Lord. Yes, certainly.
Yes, sir. Thank you. Please call.
Appellate side, daily list, serial number 1.
I am for the applicant, my lord. I am filing my evidence, sir.
I appear for the appellant. I do not know why this matter has been come. No notice has.
Yes, I have.
It has been given to me.
Yes, I have filed an application for addition of party in this matter, my lord.
Lordship, I am led by Mr. Omnaran Rai. Lordship, kindly pass it over once.
No, what is the application?
Yes, I have filed an application for addition of party because the applicant before Lordship.
Which is your application? Can 2.
Applicant addition of party.
And who's the applicant in Can 2?
Can 2.
No. You have filed Can 2
yes.
for addition of parties. What is the
applicant before Lordship? He took loan from the bank. But this is a cash credit loan and term loan. Amounted to 4 crores. What happened? The term loan was sanctioned, but that was not. The loan was sanctioned. It was given to kept in the bank account of the applicant. The loan was not disbursed. The first loan was disbursed in the month of June 2012, but they have started for deduction. They have calculated for deduction from the month of February 2012. Thereby, 18 months moratorium was not given.
Your property was sold.
Yes, my lord.
And who has purchased your property?
My purchased the property. Writ petitioner herein. He purchased the property herein. Now, what happened during the period of status quo? But order passed by the landed debt recovery tribunal. But even if the sale notice was issued and property was sold during the still that application before the DRT is pending, the status quo there, but they have sold the property. And now what happened?
No. The writ petitioner, Tamal Datta, he is the purchaser.
He is the purchaser.
But he filed the writ petition and a direction has been issued to return the amount which has been appropriated from him.
Yes.
Against that order, the bank is on appeal. How are you interested in this matter?
How did he come to know of this appeal? That is the only question. After 2023. The appeal has been filed.
But-
Now he is filing an application for
Yes.
addition of party.
What
And
happened?
what are the grounds, my lord, will kindly takes?
But now, my lord,
What is the reason? He is before DRT. He is writing to the chairman of the bank. He is writing to the PMO office.
No. The auction is under challenge before the debt recovery
But I know,
tribunal by your client.
But
Maybe there is some status quo order, there is no order, etc. We don't know. But in this case, the purchaser does not want to proceed with the property. According to him, there is some dispute in the schedule of the property, description of the property. He succeeded in the writ petition. Writ petition and the single bench directed the amount of 38 lakhs to be returned to the writ petitioner, against which the bank is on appeal. You are not, you independent.
yes, I know, my lord.
Hmm.
But before the DRT, my lord, bank filed an application under section 13(2), my lord, they filed an application with DRT. I have also filed an application before the DRT. The status quo maintained. That should be maintained. My lord, during the period, they have sold this property.
Now, this case,
Yes, my lord.
the only issue is whether the bank should return the money to the auction purchaser
That is
or
the,
should not.
yes,
Whether they can forfeit the amount or not. We will make an observation
Right.
that it is open to the applicant. What
Right.
is your client's name?
my lord. Blue View, my lord.
Blue View Poultry and Agrotech
My lord.
to independently agitate the matter before
That he is doing their DRT.
the Can 2 of 2025. This matter has been listed under the caption to be mentioned at the instance of the applicant in Can 2 of 2025, which is a company under the name and style Bulu VULU View Poultry and Agrotech Private Limited. The said company is the borrower of a loan of certain credit facilities. The applicant was sanctioned certain credit facilities by the respondent, by the appellant bank, namely State Bank of India, Bankura branch. The matter has now travelled up to the debt recovery tribunal at the instance of the applicant, and the matter is pending. The property of the applicant was put up for sale by the appellant bank, and the writ petitioner, Tamal Datta and others, were the successful bidders. However, they pointed out that there is some error in the description of the property. As a result, they contended that the amount which was paid by them should be returned. Since the bank did not oblige for such a request, the writ petition in WPA 3440 of 2023 was filed, in which a direction has been issued upon the appellant bank observing that if the writ petitioner does not succeed in the sale on 28 February 2023, the bank shall return the amount which has been appropriated to the writ petitioner within a time frame. The State Bank of India has filed an appeal against the said order. The present application in Can 2 of 2025, which has been filed by the borrower, is for addition of parties in this appeal. In our view, the applicant, namely Bulu View Poultry and Agrotech Private Limited, is neither a proper nor necessary party to the present proceedings. As the applicant has already approached the debt recovery tribunal for certain reliefs, it will be well open to the applicant to pursue such remedy before the debt recovery tribunal. And the question of impleading the applicant as a respondent in this appeal does not arise. Accordingly, application is this. Next.
Serial number 2.
Kindly
Mr. Rai is here. But I am praying for 2 days accommodation, my lord. I am not well, my lord. I am running high fever.
My goodness.
So, my lord, any day, Monday, your lordship take up, I'll do the matter.
Next Wednesday.
Next week.
At the request of the learned advocate for the appellant, next Wednesday.
Grateful, man.
Yes, Mr. Mukherjee.
Happily.
Man, I am being letting Mr. Rai in this matter, man.
Yes, yes.
Grateful.
Mr. Rai,
My lord, I am for the response.
My lord, my lord, in item number 3, my lord,
project.
Mr. Torunjyoti Tiwari is appearing on behalf of the appellant, my lord.
where is he?
My lord, he has not come to the court, my lord.
No, last
Personally-
occasion also, my lord, they have.
But it is true, my lord. I beg apology, my lord. My lord, kindly grants only 1 day accommodation, my lord. This is what has
The
been.
problem is the same appeal gets listed.
I'm sorry, my lord. My lord, there is a emergency, my lord, for which he could not come, my lord. My lord, kindly grants only 1 day accommodation, my lord.
What was the prayer in the writ petition?
My lord, he is praying for the, my lord, wages or, my lord, provident fund and etc. service benefits from the arts to oil prior to the, my lord, vesting of the Supreme Court's order, your lord, signals the Coal Mines Act. Under the provisions of Special Coal Mines Provisions Special Act, well, let's see, it is clear that no liabilities of the either government or the successor
How to
bidders.
decide that in a writ petition?
My lord, but I'm not in possession of any instructions, my
No,
lord.
no.
Kindly, my lord, grants.
No, no, wait. Petitioners are permanent employees of Durgapur project and under the Damodar coal so and so.
My lord, Durgapur project came subsequently after the, my lord, Supreme Court's order.
This intra-court appeal is directed against the order dated so and so in WPS so and so. The writ petition was filed seeking for a direction upon the respondents to direct them to appoint the writ petitioners as permanent employees under the Durgapur Projects Limited, as the writ petitioners were under the Trans Damodar Coal Mining Private Limited as trained and skilled coal mining workers. Further, the writ petitioners prayed for payment of salaries due and payable for a period of 62 months till May 2020 with interest. Semicolon, to direct the authorities to deposit the due amount in the Provident Fund accounts of the writ petitioners and to direct the authorities to take steps against Durgapur Projects Limited for committing fraud upon the writ petitioners. The learned single bench, in our view, rightly dismissed the writ petition on the ground that the claim for making them permanent employees of Durgapur projects, Durgapur coal projects, is undoubtedly a service matter for which service matter pursuant to a contract. And the question of entertaining a writ petition for such a relief is not maintainable. And accordingly, the writ petition was dismissed. If the appellant writ petitioners claim that they should be absorbed by the entity which took over the Durgapur, I'm sorry, the, what is that? Took over.
Well, they are the contract leaver. I'm very sorry, my lord. We have no relation with them, my lord.
I was praying for 1 day accommodation only, my lord.
Then the remedy lies elsewhere, and such matter cannot be adjudicated in a writ petition. Therefore, we find no grounds to interfere with the impugned order appeal.
Great.
Sorry, sir.
Great.
Next.
Serial number 4.
My lord, I am for the applicant, my lord. My lord, advocate on record. Last, my lord, advocate has died, my lord. That is why last week I have received and checked up that service has not been yet affected, my lord. In 2002, my lord, if your lordship kindly allow me 2 weeks time, I shall.
Who are the learned advocates who appeared for the?
My lord, Mr. Jagabandhu Mondal, my lord, has died, my lord.
Jagabandhu Mondal.
Yes. But individual service was there, but the service has not affected. I have checked up, my lord, in 2023, my lord.
My lord, Mr. Naik is for the WBACDCL, Mr. Sujan Naik. Copy has not served,
My
as
lord.
he mentioned that service is not completed.
Yes, my lord. Affidavit service there. Effect হয়নি দেখছি তো।
All right. List the appeal after service of notice is completed.
My lord.
Next.
Serial number 5.
Well, at item 5, I appear for the applicant. That your lordship has the occasion to take up this matter earlier. Supplementary file করেছে? But I have already filed a supplementary affidavit that in connection with the mandamus appeal. But I have challenged. But I request your lordship to first look into the first order of justice of the first court, page 62 of the stay application. So, 62. That's it. Stay application. You mean supplementary election? But the order dated 7th of September 2022. Got it?
One second. There are two you have filed two supplementary affidavits, is it? No.
No, one.
Oh, you
Probably it is the second judge's copy. Edo Judge Sahib ki help koru?
yes.
Chief Justice. On page 62 of the stay application. Not the supplementary.
Yes.
But it is ordered 7th of September 2022. Got it? Yes. But the learned judge held it was my writ petition at my instance. The petitioner claimed that the private respondents are disturbing the peaceful possession of their medical shop. The petitioners also claim that they have been running this shop room for 50 years. It is also submitted by the petitioners that they have filed a civil suit being title suit number so before the London Civil Judge, Junior Division, Islampur, Uttar Dinajpur, and have obtained an order of injunction. The private respondents, on the contrary, submit that their father had filed a civil suit against the petitioner for cancellation of the patta in the year 1967, and the same was decreased ex parte. The private respondents have also filed another suit, which is now pending before the London Civil Judge, Junior Division, Islampur, Uttar Dinajpur. In these circumstances, this court is of the view that the parties may agitate their grievance, their civil disputes in the pending civil case suits. Both the parties are directed to maintain absolute peace in the said locality and shall not disturb the possession of the shop room which is lying in the with the petitioner. Title of the parties, title and patta of the property will be decided in the pending civil suit. Then, officer in charge of the so-and-so police station shall ensure that there is absolutely no breach of peace in the local and shall maintain strict vigilance. Now, this order was not complied with. I filed a contempt application. Now, your lordship turns to page 67. The order passed on 5th of January 2024 by the same learned judge. This is there is some dispute between the private respondent and the petitioner as to whether the shop room has been closed. The officer in charge of so-and-so police station under Islampur Police District submits that he has joined his post on May 26, 2023. He has come to know from the inquiry that the shop room was lying locked much before the order dated 7 September 22. Then it appears that a subsequent order has been passed by this court on March 21, 23 in WPS 1, which is annexed in the contempt application. The said order has not been placed formally before this court on the earlier day. In the above circumstances, this court directs the parties to agitate their right to possession of the property in the pending civil suit number so-and-so. The parties may make appropriate application in the court below to seek relief. Contempt application is thus disposed of rules so-and-so. By this order, the first court, the honorable first court, has practically modified the principal order which was passed by that court on 7th of September 22. My first point is,
you invited that order by filing a contempt petition.
But I tell you, lordship, there was some, that is why the supplementary affidavit was required. But kindly sees, if I am having a permanent injunction over the property, and I have mentioned it before the first court, but the first court on that premise passed this order, first order of 7th September. Now, when I filed the contempt, a police came and filed a report that I was not on duty on that day, but I have come to know that the shop room was closed from this date to this date.
That will run contrary to your injunction order.
Yes. But kindly have a
What
look.
is the stand of the police now?
Lordship, the civil suit is pending,
Correct.
and petitioner filed 2 writ petition, and that petition, there is no direction upon the police authority to restore the
No,
position of
he is
the.
not asking for that. What he says is, he went before the court alleging contempt. In the contempt petition, your officer in charge, who was not in duty on that day,
Lordship.
he said, on inquiry, I came to know that the shop, that will be
room is-
running contrary to the order passed by the civil court.
Civil court, Lordship, the civil.
Sir, civil court has, if it is granted an order of injunction, there is a disobedience of that order, he will approach the court for contempt as well as for police protection. Or if the private respondent has unauthorizedly put up a lock, he will ask for it. So this the observation should not come in the way of the appellants for pursuing the civil remedy, because this finding shows that this finding is to the effect that before the order passed in the writ petition, the top room was locked.
No.
According to him, he is in possession, got an order of injunction, interim injunction. So we will vacate this and leave it open to the parties to agitate their rights before.
Regarding injunction, he has not informed before the police authority.
Who's
Okay,
saying?
Lordship,
All
But the
kindly see
injunction
the-
order is annexed.
All right. This intra-court appeal is directed against the order dated 5/1/2024 in WPCRC 4 of 2024 in WPA 17062 of 2022. The writ petition was filed alleging that the private respondents are disturbing the peaceful possession of the writ petitioner's medical shop, which they claim to be running for about 50 years. Admittedly, civil suits are pending, and it was submitted before the learned writ court that the writ petitioner had obtained an order of injunction in title suit number 54 of 2018 on the file of the learned civil judge within bracket junior division bracket close Islampur, Uttar Dinajpur. When the appellant filed the contempt petition alleging disobedience of the order passed in the writ petition dated 7/9/2024, the officer in charge of Golpokhar police station stated that he had joined the post on May 26, 2023, and he has come to know from inquiry that the shop room was lying locked much before the order passed in the writ petition dated September 7, 2022. The appellant is aggrieved by such observation. Admittedly, the learned writ court took note of the order of injunction obtained by the appellant in TS number 54 of 2018, and thereafter directed the both parties, namely the appellant and the private respondent, to maintain absolute peace in the locality and shall not disturb the possession of the shop room which is lying with the petitioner. Therefore, in the contempt proceedings, the order and direction issued earlier in the writ petition could not have been modified, and the modified and any observation modifying the earlier direction would grossly affect the rights of the appellant in the pending civil suit. Therefore, the observations made in paragraph 2 of the order dated 5/1/2024 is set aside, and the appellant as well as the private respondents are at liberty to agitate all their rights in the pending civil proceedings. The appeal stands disposed of accordingly. Next.
But only if you add only one line. But regarding the maintenance of absolute peace and no disturbance of the shop room, only this line.
That we have said.
I'm
Next.
so great.
Next.
So great.
Number 6 and 7.
6 and 7.
Lordship, the number 7 is wrongly attached 27. My mat is 57 of 25, Lordship.
Yes,
All
your
right.
Lordship.
We'll come to it. We'll come to it. 1 second. Who appears for mat 1904?
I am, Lordship, my appeal, Lordship. I learned junior is here there, Lordship.
I am led by Mr. Vijay Kumar.
You are appearing.
1904. I filed two appeals. One appeal from the review application and another appeal from the original order. Review application is appeal is Lordship 1904 is listed, but original order from the original order 57 of 25 is not listed. 57, Lord. In place of 57, court is listed 27, Lord. Mistake.
57.
57.
My
But
lord,
where is,
and
where is the original order passed?
Oh, Lordship,
Where is the original order passed in the writ petition? Copy
I
of that.
file appeal from that 57, Lordship, the Met 57, Lordship.
Oh, in this mat, you have not enclosed that order.
No, in this Lordship include the appeal from the review of the order. Order from the review.
Second ম্যাপটা হচ্ছে 57 হবে 27
Page 24 is the original order, correct?
Lord,
Correct.
Lord. 57, my Lordship, in this matter,
Sir,
Lordship,
sir, page 24 is the original order. Am I right?
Lordship,
Please assist the court, sir.
Lordship.
Please
Original Met is very necessary.
No,
57.
Mr. Vijay Kumar, 1 second. Sir, please verify. Please verify whether page 24 is the original order.
Right, my lord. Of my lord, first appeal, my lord. But second appeal, my lord, is my lord a wrong book.
That he has said, sir.
First appeal, not original order, my lord. But we, my lord, our writ order was passed, my lord. Thereafter, my lord, we file a review application, my lord. That review application was rejected, challenging that, my lord. First appeal was filed, my lord. Now, my lord, again, my lord, we had filed another appeal challenging the main order, my lord. Become nice, man.
Now the direction was issued to release the balance amount of coal.
Yes, my lord.
You filed a review against that order, correct?
Lordship.
But we want to show, my lord, to several circulars, my lord, that now, my lord, releasing coal, my lord, is not permissible, my lord. And my lord, that also, my lord, will show, my lord, that the person who is supposed to get that the coal order, my lord, he has not come, my lord. Some power of attorney holder, third party, my lord, has come, my lord. So there are some.
Another thing, Lordship, we have not taken any inch of land from the petitioner, Lordship. He fraudulently obtained the order about 20 years ago.
Both the matter may be hard together, my lord.
The correct number is MAT 57.
57, my lord.
Of
57, Lordship.
25.
Of 25.
57 or 25, Lordship.
In the order dated 5/2/2025, this by order date 25, this appeal in MAT 1904 of 2024 was directed to be listed along with MAT 27 of 2025. Mr. Binoy Kumar, learned advocate appearing for the appellant, submitted that the case number has gone down wrongly and the correct number is MAT 57 of 2025. Let this appeal be listed along with MAT 57 of 2025 and after service of notice is completed on the respondents.
Deeply appreciated. Grateful, man.
Grateful. Serial number 8, my lord, I am for the applicant, my lord. What's happened, my lord, the copy has not been served.
What is the matter, you tell? If there is anything, we'll see.
Also, the section 5 application is pending.
Also kept on record. Petitioner claims he has had a
59
dispensary
days.
at the premises, which originally belonged to his mother-in-law. 20, he had been unable to operate this dispensary after demise. One Abhijit Gahan is in possession of the house and having a tea shop, which has surfaced in the local inquiry. In case there is a dispensary which is under lock and key and submitted so and so in the enters in such review, he should not be resisted or harassed.
That portion I have been, my lord, agreed, my lord. That portion I agreed, my lord. The person petitioner is not in position suppressing the facts. My lord, the Abhijit Gan is the appellant herein. No notice was served before moving this read application. My lord, by virtue of that, the third party, my lord, the disturbing the position.
All right. List this appeal after 2 weeks in the admission list after completion of service of notice on the respondent.
Along with the condemnation delay, my lord.
Yes, along with the, let the appeal be listed along with the application for condemnation of delay. How many days?
Oh, 89 days.
89 days. Okay.
Practically, my lord, the only deducting 30 days, my lord, only, my lord, the
All, let us see. Please
59 days.
complete service. Next.
Serial number 9.
Madam, I am for the appellant. Madam.
I am not responding.
Madam, I am filing my affidavit of service. Madam, the writ petitioner moved the writ petition praying for an order upon the police to give protection in terms of the order of the learned civil court. Madam, the learned.
So why you could have filed an application before the civil court? They would have directed the police to give assistance.
Madam,
you are there in the civil court. You are filing a writ petition.
Madam, I am not. I have not filed the writ
You filed. You filed the writ petition.
They have filed. Madam,
this
Madam,
suit was
kindly consider the judgment of the civil court. Madam.
Suit was ultimately degreed.
Page
Now, my lord,
52 and 3 is the relevant
my
portion,
suit-
my lord.
My suit was ultimately degreed. This is with regard to a tank.
But injunction refused.
The suit
If
parties
if the suit was decreed,
in my favor.
can you file a writ petition for executing?
No, I am not executing. Well, kindly see the impugn order. Court has not granted any relief to me. Kindly see the order. My lord. Court is not granting any relief to me. Kindly see the order, my lord. However, my lord, may I just come back to the second page of the order? However, I find that the learned.
Please see the prayer in the writ petition.
My lord, the court has not allowed my writ petition, my lord. Court is not mean, my lord, granted any prayer.
The writ petition was not maintainable to execute a civil court's
No,
decree.
court is not directed to execute, my lord.
No, prayer in the writ petition was to take necessary steps to provide police posting, restraining the private from creating obstruction, so and so, tank over so and so, so and so, in compliance of the judgment dated 5/6/2023. What is
No, my lord, may I just not.
You file an execution application. If there is any obstruction, or you can take out another application to provide police protection so as to implement the decree.
My lord, may I just not draw your lordship kind attention to the impugn order once, my lord. Your lordship kindly see, court has directed, that is, my lord. This honorable court, this jurisdiction of this court obviously is not to decide the right title interest, but to ensure that the both party can enjoy their property. So it is a party, unpartisan land, party's property.
The police should keep strict vigil, ensure no breach of peace.
That is, my lord, with regard to criminal offense. My lord, that is, my lord, with regard to the criminal offense. Court has not been directed.
Liberty was granted to enter into the land, my lord, where the learned civil court refused the injunction. My lord. This is joint property.
My lord, may I just, my lord, draw your lordship kind attention once, my lord.
No, we'll clarify. We'll clarify. This intra-court appeal.
My lord, only one thing, my lord, there is a, my lord, your lordship was, my lord, if my title has been decided by a competent court of civil court.
We cannot set aside that decree.
Yes.
We cannot. You enjoy the decree, fruits of the decree. This intra-court appeal by the private respondent in WPA 19493 of 2024 is directed against the order dated 4/10/2024, wherein the learned writ court, while
and the order was already effected, my lord.
While bringing on record that the learned civil judge within bracket junior division, third court, Diamond Harbour, has passed an order which gives right title and interest also to the writ petitioner, observed that the jurisdiction of the writ court is not to decide the right title and interest, but to ensure that both the parties can enjoy the property. There was other directions given to the police to keep strict vigil in the area and ensure that there is no breach of peace and tranquility. Before we, at the outset, it needs to be pointed out that the prayer sought for in the writ petition was in effect to execute the decree passed in title suit number 92 of 2021, dated 5/6/2023. If the respondent writ petitioner has a decree in his favor, nothing prevents the respondent writ petitioner from executing the decree in the manner known to law. And the writ court cannot be converted into that of an executing court. Therefore, any observations made by the learned writ court touching upon the effect of the decree will be wholly without jurisdiction, and accordingly the same is set aside. However, if any criminal offense is committed by either party, it will be well open to them to approach the jurisdictional police authorities, who will take action in accordance with law. With the above observation, the appeal is allowed to the extent indicated. Next.
Grateful.
Serial number 10.
10. You are for the state.
For the WBS respondent, my lord, West Bengal State Electricity Distribution Company.
Yes. What is the order?
Yes, my lord. I beg to appear for the appellant.
It is sort of.
Who will appear for WBSC DCL?
My lord, we are appearing.
Who will
I'm
appear?
being led by Mr. Devjit Mukherjee, my lord. He is coming.
Yes, my lord. I beg to appear for the appellant, my lord.
What was the prayer you sought for in the writ petition?
Yes, my lord. There was a one interim prayer I was sought for, and another is for the connection that was been disconnected by the licensee company. That is to to give the connection again, for the reconnection of that electricity line. What happened, my lord? I am running a business on independently upon my husband's land, my lord. My husband has 3 land, my lord, and the 3 land is there in the petition. Now, my lord, in one land, I am running the business independently. My name is Hira Boshak. I am running Hira Boshak, Hira Bar and Restaurant. This is the bar and restaurant I am running. Now, my lord, what happened? One fine morning, the licensee company disconnected the line. Now, my lord, this whole, what is the problem in the petition? That I have to battle for the Topon Boshak as well as Hira Boshak. The petitioner and petitioner's husband is not before this court. He is running another restaurant. Now, my lord, what happened? When petitioner's husband went to the licensee company's office, they have said there is one outstanding in your premises, and there is a one outstanding in the same premises, unless and until you clear the dues of your brother, who is private respondent here is in the petition, my lord, then we are unable to give you the connection, then we'll disconnect. Now, my lord, on that ground, we have made the writ petition before Justice Sinha. Now, my lord, what we have prayed, that the private respondent's line hotel was not within the premises of petitioner's land, my lord. That is the outside of the, my lord, premises. And the rules of the licensee company itself says that only the dues can be occurred from the other person, my lord, if that is in respect of the same premises and if there is a nexus. Now, my case is, my lord, this is not within the same premises. The fact is, my lord, the private respondent was cheated with the licensee company at the 2014, my lord. Then a trial took place. Case has been registered, my lord. At the trial, he get acquitted. But whatsoever the civil liability is upon the private respondent, my lord, that is at around 8 lakhs
How
of
many
rupees.
connections are there in the premises?
That is a commercial premises, 2 connection. One is of mine and another is of my husband. My husband is not before this court. I am, my lord, independently, my lord, I am running my
How many
business.
meters are there?
2 meters.
2 meters are there.
2 meters.
So now the husband's brother,
yes,
he is the private respondent here.
Yes.
And he has committed theft of energy, is it, or some default?
Yes. Yes.
And that default has not been cleared.
No.
That outstanding is still remaining.
Yes.
Now they have disconnected your supply on account of that outstanding.
Yes. Because, my lord, there is one
And what is the finding of the learned single bench?
line. Kindly come to the
petitioner really various documents.
The finding of the single bench was we had a nexus between my husband and the private respondent. We are belong from the same family, and for that reason, that is liable to be disconnected, my lord. My lord, 25, page number 6 of my mat. On the contrary, it appears that there is a nexus between Swapon Boshak, Topon Boshak, and Hira Boshak. They are all members of the same family. They are staying in the same premises. This is not, my lord, not on joint family. Topon Bosak usually runs the business of Topon Bosak in the name of Bojrangboli Line Hotel. The petitioner number 2 is also in the same restaurant and same hotel business. This is also not, my lord. All will be benefited.
Then who will appear for WBSCDC?
Right.
Yes.
Yes.
No, his case appears to be there are 2 electricity connections.
But there are 3 electricity connection. What happened, my lord? The brother, who is a private respondent in the writ petition, he has, my lord, tape electrical energy. The lordship knows we have initiated proceedings. Thereafter, he came before this court. This honorable lord did not entertain. Thereafter, my lord, ultimately, my lord, criminal case has been started. He has been acquitted. Now, your lordship knows civil consequence and both are different. Now he has to pay that amount that he has not done. What happened after, my lord, that the order of the criminal court, this particular gentleman, the husband of the writ petitioner, came before our office. On oath, we have stated before the court. Everything has been done by him. He came before our office and said that my brother has been acquitted, therefore kindly restore the line. Now, initially, what happened, my lord, when the connection has been given, it is a fault on our part that we have not considered that there is another meter which has been disconnected. In the regulation of the West Bengal State Electricity Distribution Company, it provides that, my lord, if there is a disconnected meter, we cannot supply any new connection in that premises. Now, here what happened from the conduct, my lord, on oath we have stated before the honorable single judge. I don't know whether that has been annexed or not. We have specifically stated what are the facts. Everything has been done by the husband of this petitioner. And, my lord, although private respondent was made party, the brother, but
didn't appear.
I don't know whether summons has been served or not. He chose not to appear for the argument's sake. Now, from the, if your lordship consider the honorable single judge, my lord, if your lordship see, my lord, from paragraph 3, may I just read for your lordship? The honorable single judge has considered everything. If your lordship kindly permit me to read, my lord. The intention regarding disconnection of commercial meter addressed to the husband of the petitioner number 2, Topon Bosak, dated 4th October 2024, mentions that during inspection by the official inspection team at the commercial premises, it was found that one service connection exists in the name of Mr. Topon Bosak, which stood disconnected on 20th March 2016, and the amount remained unpaid for a considerable period of time. 2 other existing electric meter at the same premises in the name of Topon Bosak and in the name of Hira Bosak, along with the service cable and all materials, installation, etc., from the premises were dismantled as per the WBEDCL norms, WBERC regulation. The letter indicates that such step was taken in consultation with his brother Topon Bosak, as told had blood relation between them. Specific case of the petitioner is that the premises of Topon Bosak and Topon Bosak are separate. The relationship between Topon and Topon is not cordial. For non-payment of dues by Topon Bosak, the licensee ought not disconnect the electricity in the premises of either of the petitioner or Topon Bosak, the husband of the petitioner number 2. It has been submitted that as there is no electricity, the petitioner number 2 is not in a position to run her business, resulting in financial loss. Her life and livelihood is at stake. Reference has been made to the regulation and other thing. Now, kindly, my lord, instead of regulation, kindly straightway come to the finding, my lord. Madam, paragraph 8. It has been submitted that the petitioner in no way have benefited from non-payment of outstanding dues. The regulation mentions that the outstanding dues of the service connection have to be or has to be in her name, as the meter with outstanding dues stand in the name of somebody else and not in the name of petitioners. Accordingly, the licensee ought not disconnect the electricity connection. An information slip has been filed to show that partition suit is pending. Now, kindly straightway come to, my lord, paragraph 15. It has been submitted that there is clean and clear definite nexus between the parties. This is my submission before the honorable single judge. Documents have been annexed to the affidavit in opposition starting from the year 2014 show that the parties are residing in the same premises. The application for reconnection filed by Topon Bosak was actually submitted by Topon Bosak, the husband of the petitioner number 2, by mentioning the phone number of husband of the petitioner. It has been submitted that the inspection report of the licensee clearly indicates that the meter at the same premises, Topon was enjoying electricity from the connection of the petitioners. It has been submitted that pendency of the civil proceedings in between the parties does not necessarily imply that the relationship between the parties is not cordial. It has been pointed out that the title suit is a sham one and has been deliberately filed only to show the relationship in between the parties, which is for a fact it is not. It has been argued that the discharge from the criminal liability does not ipso facto mean that the consumer will be let off the civil liability. He is required to discharge the due the private respondent is nearly rupees 8 lakhs. Till the outstanding payment is made, the distribution company limited will not be in a position to reconnect the supply. Learned advocate for the distribution company distinguishes the judgment and now findings. Upon hearing the submission made on behalf of the parties and on perusal of the materials on record, it appears that petitioner has relied upon various documents issued by the distribution company limited in favor of the private respondent in whose name the meter is standing with outstanding dues. The petitioner nowhere disclosed in the writ petition with regard to the source of the said documents. It has been, the documents which has been annexed to the writ petition, all of the documents of that person whose line has been disconnected and theft of electricity. No matter where from, if the relationship is bad, no question arises for getting all those documents, the original. Then, it has been submitted in court that the documents were handed over by the staff of the distribution company limited. The court fails to understand as to how the staff of the distribution company limited could get hold the postal receipt of the article which was put to the post addressed to the distribution company limited. The postal receipt always remains with the sender and not with the sendee. The sendee has no access to the postal receipt. The letter with the postal receipt must have been with Sopon or Topon. The private respondent is not represented. The inspection report of the distribution company limited clearly mentioned the meter is in same premises. Only at one place in the communication dated 4th October 2024, it has been mentioned that the address of Sopon Bashar is next to your premises. That apart, all along the steady stand of the distribution limited is the parties reside in the same premises. The application made by Sopon Kumar Bashak for obtaining connection mentioned the phone number of the husband of the petitioner number 2. The intimation of disconnection address to Topon mentioned that such step is to be taken on consultation with Sopon, who is his blood relation. The regulation relied upon by the petitioner provides for disconnection if there is outstanding dues in respect of same premises and if nexus is proved between the defaulting consumer and the next consumers. The court is not convinced either with the submission made on behalf of the petitioner or upon perusal of the document placed before the court that there is absolutely no nexus between the parties. On the contrary, my kindly mark, it appeared that there is a nexus between Sopon Bashak, Topon Bashak, Hira Bashak. They are all members of the same family and stay in the same premises. Topon Bashak usually runs the business of Sopon Bashak in the name of Bajrangi Line Hotel. The petitioner number 2 is also the same restaurant and hotel business. All will be the benefited if electricity connection is restored without clearing the outstanding dues. The civil suit is only a feeble attempt to show that there is a disorder between the parties and with the view to disprove the nexus claim by the licensee. Topon made application for registration of trade of disclosing the name of Bajrangbali Line Hotel. In the judgment relied upon by the petitioner, court was not satisfied. Therefore, my court dismissed the same.
Now, please show your regulation, which says that if there are any outstanding dues in respect of the same premises.
That has been put in the impugned order, my lord. If you
My lord, I have the regulation. May I please?
No, it has not been extracted.
My lord,
in your affidavit in opposition, you referred to that regulation.
Subject to correction, if you lordship see paragraph 6 and 7, my lord. I will bring that definitely, my lord. Paragraph 6 and 7, subject to correction, it has been mentioned, my lord.
Mentions the licensee shall be eligible to recover from a new.
Paragraph 7, the West Bengal Electricity Regulatory Commission, number regulation 2010 has been placed. Clause 13.9 of the said regulations mention that for getting a new connection for supply of electricity from a licensee, an intending consumer shall be required to pay all outstanding dues to the
my lord. 3.4.2. Page number 11, my lord. 3.4.2.
But they are referring 13.9.
13.9. That is the main matter. 13.9. 13.9. Regulation 10, it says, my lord, if you want.
3.4.2 shows that if a nexus is there between the defaulting consumer and the other person, then it can be disconnected.
Only in respect of same premises if there is outstanding.
Yes.
And for that reason, my lord, that is also been relied. That was 2010 rule by them. That is, my lord, 13.9.
And according to you, it's not the same premises.
No, my lord, because I will place that within the writ petition, nothing from the outside, my lord. 13.9, my lord. And that has been cleared by a division being judgment of the then Chief Justice of this court.
My nexus is proved because everything has been done by him.
No, it's true. But if it's a different premises,
The premises is one, only one premises.
But the learned judge has
Learned judge has stated, my lord, kindly see once.
stated.
Finding.
My lord, the letter is in page number 68. In one paragraph, it says in the next premises, another it is said the
No, my
same
lord, not
premises.
that, my lord.
What is the door number?
What is the?
The door number of the
Same.
My
lord, in that.
No. If you say it is a different premises, you please produce your property tax card. You please produce the property tax card.
The property tax card of my husband?
I don't ask question to the court.
No, my lord.
According to you,
I'm just getting clear.
If there are three connections and three different premises, then this what is
My kindly see paragraph 15 and 16.
My lord.
The Honorable Single Judge has found.
Yes.
Paragraph 15 and 16. Paragraph 15, kindly see. It has been submitted that there is a clean, clear, and definite. Have your lordship got it? Nexus between the parties. Documents have been
residing in the same premises.
Yes, my lord.
Absolutely.
Are residing in the same premises.
No, this is residing, my lord. This is not even residing. The question before this
you
court.
Show the cost title. You show the cost title. Conveniently, what you do is you
Here
don't
are
give
student
the premises number. Situated in so and so.
Yes, my lord. That is also there in my application, my lord.
No. You come to page 24. Writ petition cost title.
20.
This is a clear way of hoodwinking the court. Where is the premises number? You come to page 24.
There is no premises number, my lord. He ought to have annexed the affidavit in opposition before your lordship in the state petition.
It is annexed.
Yeah.
Page number 72.
But my lord.
No. This is you are trying to cheat the court also.
No, my lord. Pardon me, my lord. My lord, I have
You have given the district post office name of the post office and the district pin code number. Where is the premises number?
Premises number, my lord.
Obviously, it will be there, no?
But kindly see, kindly turn to my lord, page 84.
My lord, that
page
is
84.
My lord, that is where, my lord, we reside.
Page 84, your lordship will find. This is the letter of Shopon Moshak at the signature. Right hand side. Kindly see the left hand side, the mobile number. This mobile number belongs to the husband of the petitioner. He, from the very beginning, he is saying there is the relation.
If according to you, there is a factual error committed by the writ court in respect of the premises.
Yes, my lord.
Your remedy is by way of a review. We cannot test it. You are not being established. You are not being able to establish that your restaurant is being run in a different premises with different door number. Your husband's premise is different.
My lord, the document is there in petition, my lord. My lord, the cost title is where I reside, my lord. This is land in question where the student is situated.
We will dismiss it with cost. First writ petitioner is the hotel cum bar.
Yes, my lord. I am the owner. The second one is the owner.
Where is the premises number I am asking? This intra-court appeal by the writ petitioner is directed against the order dated.
May I leave it?
Order dated 27/11/2024 in WPA.
May I leave, my lord?
26599 of 2024. The writ petition was filed seeking for restoration of the electricity connection which was disconnected. The learned writ court had elaborately heard the matter, took note of clause 13.9 of the West Bengal Electricity Regulatory Commission notification, as well as clause 3.4.2 of the West Bengal Electricity Regulatory Commission (Electricity Supply Code Regulation 2013), and has thoroughly analyzed the factual situation and has recorded a finding that there is a clear nexus between the petitioners and her husband and her husband's brother, who was impleaded as a private respondent. the petitioner, the appellant writ petitioner was not able to establish before the court that the bar cum restaurant run by the second petitioner is run in a different premises. This factual finding could not be dislodged in this appeal as well. Therefore, we find no grounds to interfere with the impugned order. Appeal fails, dismissed.
Next.
Grateful.
Serial number 11.
My lord, I am for the state, my lord.
I am appearing to the appellant, madam.
I am for the union of India.
Private risk, madam.
आप यहाँ जल्दी का चलो और उधर का चलेंगे
No. Respondent 2 and 3.
कोई तो उठा चाहिए ठीक है तो
My lord, I am appearing to the appellant, my lord. This is the matter, my lord. That is, my lord. The appellant is unfortunate prospective adoptive mother, my lord.
But your application cannot be accepted in the portal.
Portal has not been accepted, my lord. Though the petitioner, my lord, filed the application within the time, my lord. My lord, but my lord, portal is paid, my lord, only 3 types of child. That is, my lord, orphan child, abandoned child, and my lord, 3 types of child, my lord. This child is not come with that, my lord.
But now the child has attained majority.
But my lord, when my lord, kindly consider, my lord,
No,
when
no.
the application has been made, my lord, then my lord, the child was beyond 18 years, my lord. Kindly come to my application for a moment, my lord. Kindly come to my lord.
Page.
I am coming.
Further.
Page, my lord, 72, my lord. Of application. 2nd January 2025, my lord.
Correct. What was the age of the that boy on that date?
My lord, on that day, my lord, the petitioner
17 years, 9 months.
9.
17 years, 9 months.
17 years, 9 months. Now it's crossed
9 days, my lord. 17 years, 9 months.
Now today, see, we can't, assuming the adoption was permissible, it cannot be with retrospective effect.
My lord, if my application, my lord, allowed, my lord.
Only somebody is a civil suit.
The CARA guideline, now the application is to magistrate. Earlier it was before the district judge
Yes.
for adoption under this CARA guideline. In
CARA, my
terms
lord,
of
portal, I have tried, my lord, as this child.
No, you can, that is why the learned single bench has granted liberty for you to file application as per before the Central Adoption Resource Agency, CARA.
I have filed, my lord.
Where is the application, madam? That is a letter. Page 72 is a letter.
This is, my lord, application. Portal does not allow me, my lord.
My lord, what happened here?
You are for CARA.
Well, I am
I am
for the
father.
father.
May I
I am for the
submit,
father.
my lord? He is for father.
I'll explain the
Here,
facts.
Kara will not applicable. Why? This child was not surrendered.
Yes.
My lord, he is looking after, she is looking after this child since long. My lord, I am, my lord, destitute man. My lord, I am going to, my lord, be a saint. I am leaving the family members. Therefore, she wants to have this child as his son on adoption. My lord, under this Kara regulation, unless the son is surrendered, nobody can take this son.
No, 3 times.
Then
Well,
Hindu Adoption
therefore-
Maintenance Act?
Your Lordship, I am for Kara. What happened? They first, according to them, they attempted to register their application through the portal. But according to them, they alleged that they failed, so they made an application in writing. That application prays for, in the last line, prays for permission from us. We have no authority to grant permission, my lord. We have no authority. And we deal with only with orphaned, abandoned, and surrendered children.
If the
Nobody.
if the biological father agrees to surrender the child,
Yes, that is
Right.
the.
you are agreeable.
Yes.
No, that's a long
One-
process.
It's also been given, my lord.
I am going away. Well, this.
But the problem is now it is
That's-
not a
No,
final-
even coming before us, before coming to us, they had to complete that procedure of surrendering to the making application before the competent authority.
Who's the competent authority for surrender?
That is in their rule, Your Lordship.
Please suggest a way out how it can be resolved. He is very eager to take.
Yeah, yes, Your Lordship. I'm sorry. Yes, Your Lordship. I was thinking about that since last day. Your
In
Lordship
fact, we
told me.
suggested to her
Yes,
last
I have really full sympathy for this matter, but I couldn't find it because we are nobody here, Your Lordship. We are nobody.
My lord, kindly come to.
If they have an adoption date, I
Fine.
don't know whether they have
But
it.
under the Hindu adoption and maintenance,
Yes, they can always go to the district court.
they can file an application before the district
But
judge.
my lord, the appellant is a scheduled tribes woman, my lord. And my lord, the child is Hindu, from Hindu family, my lord. That is the main problem, my lord.
Can you not say the suit? Hindu adoption and maintenance.
Civil suit won't be maintainable.
It is Hindu adoption.
Hindu adoption and maintenance. No. who Hindu.
সোনার লতে যেটা সেটা এখানে কোথায় অ্যাঙ্কেল 226
What যেখানে 19 না 9 করেছে
Section 98.
না
No, the writ petitioner is a 46-year-old unmarried scheduled tribe woman. But what about the child?
Hindu.
Hindu. Your Lord.
Hindu. So therefore, this adoption and maintenance act will be applicable. You can go before the district judge.
They had time even.
My lord,
Since the last order, my lord, they had 8 days to go before the district court. Even the honorable court suggested that, but they didn't opt for that.
my lord, last
It's not in the
petition
order.
I have submitted before your lordship, my lord, a memo, my lord, sent by the district social welfare officer, my lord. Kindly see, my lord.
Yes. Where is that memo?
No, Hindu.
You read.
My lord, from third para, my lord, I am reading, my lord. The district is seeking adoption related to under section 56 of Juvenile Justice Act 2015 and its rules and the adoption regulation framed by the authority concerned, Kara, my lord.
আরে দূর বাবা অ্যাডপশন অ্যাক্টে চলে আসবে
Hindu adoption act.
এটা তো আসবে না সিভিলে
The scheduled tribe falls under the definition of Hindu, my lord, in the Hindu. Yeah, your
See,
lord.
why before the learned single bench, they had advised you to file a civil suit. You could have filed a civil suit.
And they had time.
Huh?
They had time at that time. The person didn't reach the age 18 at that time. Instead, they further agitated.
age will be the obstruction, my lord. Kindly, my lord, allow.
No, how?
My lord,
Madam,
my lord,
you are,
my lord, proceedings has been started, my lord. Kindly, my lord, consider, my lord, proceeding has been started, my lord, beyond 18 years. That is, my lord, my respectful submission before.
when the learned writ court had suggested you to go out before the civil court, the child was a minor. You did not accept that suggestion. Therefore, they said Kara will not apply unless and until the child is surrendered.
Absolutely.
Now the biological father cannot surrender because the child has become a major. What is this, madam? We last occasion itself we advised you. You are not examining the legal position and you are saying issue direction, issue direction. Can we issue direction against law? Can a major a person who's attained majority, can we say you Kara will accept the application and recognize the adoption?
Your Lordship, we have no authority.
And he has, they have no authority unless an adopted, the biological parent surrenders the child. The best way is to file a civil suit.
Your Lordship.
Right.
Right? No.
He has attained majority.
Yes,
So how question of adoption comes then?
The petitioner, the appellant was the writ petitioner, wherein prayer was made to permit her to adopt a child, a male child, who at that time was aged 17 years, 11 months and 15 days. The learned writ court directed the applicant to approach to file an appropriate application before the Central Adoption Resource Agency, within bracket Kara. Before us, Kara has been represented by the learned advocate and submitted that as of now, the said child has attained majority. Therefore, the question of entertaining an application by Kara would not arise. Another embargo is that the biological father of the child has not surrendered the child when the child was a minor, so as to enable Kara to assume jurisdiction. It appears that during the pendency of the writ petition, it was suggested to the petitioner that she may approach the civil court, which suggestion was not taken. In any event, as of now, the child having attained majority, the question of issuing any direction to any of the authorities to permit adoption of the child does not arise. Hence, appeal dismissed. Sorry, madam. Next.
Appeal number 12.
My lord, 1 point, my lord, kindly consider, my lord, paragraph 9 of the writ, what an impugned order, my lord. Where, my lord, may I read, my lord, for a moment, my lord. The court is not inclined to exercise jurisdiction in this matter, as it has been submitted that an online application for registration before the Central Adoption Resource Agency has been filed, my lord. This is the, my lord.
Wrong.
Correct, my lord, kindly, my lord.
The order.
The authorities shall take
separately.
steps in accordance with law.
Letter is there. You show this letter, top letter.
দেখি অর্ডারটা লিখে নিন স্যার সিগলে যেতে বলেন
না 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 ওটা তো ভুল আছে
Yes. Next. Item 12.
Appeal number 12.
Your Lord.
I am for the appellant, my lord, in this matter. My lord, there is an order, my lord, passed by the, my lord, the writ court. My lord, I could not appeal the ex parte order. My lord, where there is a civil suit is pending. I file a civil suit, my lord, against the, my lord, the private respondent. My lord, the civil suit is pending. My lord, in the meantime, my lord, they approach that we are, my lord, obstructing their ingress and egress. My lord, they are appeared in the civil suit. Well, my lord, the court has directed, my lord, to provide the police help so that, my lord, their ingress and egress, my lord, that is, my lord, PH order of, my lord, dated
107.
107 and, my lord, the order dated 10th of December 2024. Police authority would ensure that the ingress and egress of the petition is not been obstructed carrying on business. And
No, the court says the police authorities would ensure that ingress and egress of the writ petitioner is not obstructed. provided the business is being carried on under all lawful information.
My lord, what is happened?
You have obtained an injunction.
My lord, the injunction, my lord, we are paid for it. My lord, this is a suit for partition, undivided property. Property is not even demarcated. My lord, my lord, filed a suit and my lord, he appeared in the suit. My lord, the suit.
But the court has refused interim injunction.
Page 94.
That is, my lord, the altogether. But my lord, there is a partition suit. They appeared in the suit.
For declaration.
Suit for.
So if you are in possession of a undivided
My
property,
lord, he could have approached before the civil court for filing an application. My lord, kindly allow me because my lord, my ingress and egress are no obstructed. That is not this case before the civil court also. He has appeared there. He has not filed any application to that extent. He straightway come to this honorable court and file an application before the.
No, you are the plaintiff in the suit.
He is the defendant in the suit.
Correct.
He never, my lord, said before the civil court. Though he has appeared in the civil court, my lord, and approached before the civil court that since I have been obstructed, kindly, my lord, pass an order to the extent.
Yes, sir. What is your instruction?
My lord, so far with regard to civil court at page 90, my lord, 95.
Yes. Injunction application.
Ad interim, my lord, it says temporary injunction
There
is
is
still
no
pending.
That you argue.
Joint property, there is no, my lord, prima facie case refused. And suit for declaration and permanent injunction.
Not partition.
And partition.
No, not partition.
My lord, if he is insisting, kindly see the prayer of the suit at page
77.
Page 77.
Well, subject to the lawsuit convenience, there is one provision under Code of Criminal Procedure Code 133 of the Code of Criminal Procedure Code. If there is an obstruction to that extent, he could approach before the magistrate court under 133.
My lord, my written complaint, I am not, my lord, alleging the civil suit case. My lord, my allegation was that, my lord, they are restraining me from doing my business. For that reason, my lord, I made written complaint before the authority concerned and came before this honorable High Court. The interim order refused by the landed court below and a suit for declaration and permanent injunction, not for partition.
Well, under the Police Act, well, there is no such
And,
provision to the police. No such power under the Police Act, well, to police, well, to because well, there is a provision under 133 of the Code of Criminal Procedure Code. He can approach them under 133.
But disturbing my business.
Not the job
of the
has been filed by the 8th respondent WPA 28964 of 2024, dated 10/12/2024. The said writ petition was filed by the private respondent herein, praying for direction upon the official respondents, namely 1 to 7, to take appropriate steps against the appellant/8th respondent pursuant to the complaint lodged on 27/6/2024 and 21/10/2024 by registering an FIR and causing an investigation, as it was alleged that the appellant 8th respondent was causing threat of murder to the writ petitioner and also imposing restrictions upon his movement and also peacefully running the business in the stated premises.
My lord, I should not obstruct the court while delivering judgment. His complaint at page 36 in vernacular, Justice Chatterjee will, my lord, assist the court, is allow him to cultivate.
My lord, next page, page 97.
No, let me, I have not completed.
36, no, that is only my prayer was, my lord.
জমি ব্যবহার করতে এবং চাষ করতে বাধা দেয় বিগত
page 97.
97 top.
96, 97 top. I cannot read. If you can read, kindly say. দোকান থেকে
মধুসূদন পাল
টাকা আদায়ের চেষ্টা করছে
এবং জোরপূর্বক টাকা আদায়ের চেষ্টা করে এবং টাকা নিয়ে দিলে আমার দোকান বন্ধ করার।
Two things in complaint, written complaint to police. One, that I am being prevented from cultivating my land.
That is, they have to go to civil court.
Civil court. No, my lord,
the sub-room is with regard to the subject property
under the Land Reforms Act that he has to go, the tribunal. And my lord, with regard to, my lord, asking for, my lord, extortion of money.
That you can investigate.
That I can investigate. But with regard to, my lord, the order that has been passed, that I am to, police authorities would ensure that the ingress and egress.
That was not single judge also. My prayer was not, writ petition was not that. Only to run my business.
premises. The learned counsel appearing
They
for
are
the state
46,
pointed
47.
out that there were two allegations in the complaint dated 27/6/2024 lodged by the writ petitioner before the officer in charge, Kolaghat Police Station. The first prayer made was to uh, uh, um, ask the police to help to ensure that the writ petitioner complainant is able to cultivate the landed property. The other allegation was against the appellant / eighth respondent, alleging extortion and other allegations. So far as the complaint with regard to cultivation of a land is concerned, the police authorities cannot investigate, cannot take any action on the same. And if the writ petitioner has agreed, the writ petitioner should approach the civil court. However, the complaint of alleged extortion, threat of murder, etc., can always be investigated by the police. Therefore, we slightly modify the direction issued in the learned writ court by deleting the directions to the police authorities to ensure the free ingress and egress of the writ petitioner for carrying on his business. However, the direction to the police to investigate into the matter if any cognizable offense is committed and is made out. No, cognizable offense is made out from the information complaint, the police authorities can take action. To this extent, the order of the learned single bench is affirmed. Accordingly, the appeal is partly allowed and the direction issued to the police authorities to ensure that the ingress and egress of the writ petitioner is not obstructed for carrying on the business, he stands citizen. Next.
Bill number 13.
13.
So file certified copy and where they today plan is there. I'm going to assure.
None appears for the petition appellant. The certified copy of the impugned order has not been filed. Appeal dismissed for non-prosecution. Next.
Bill number 14.
I am for the petitioner, my lord. In this matter, my lord, I have filed two applications. I have application for leave to appeal and another application for stay of application, my lord. But the perhaps that had not had come before your lordship, my lord. Kindly make it not today, my lord, next Tuesday. And my lord, I have served already, but service has not yet been completed.
But he is not a party, no? He is a third party. He can't apply for certificate. You are for the appellant.
Lordship.
And you are not a party in the writ petition.
Lordship.
Now, how are you aggrieved by this order?
My lord, the writ petitioner made allegation against me, my lord, against us, my lord, that my lord, we have restrained the petitioner from to entering in the house. But my lord, the fact is that he has not made in the party in the writ petition. And my lord, apart from that, the writ petition, the mother of the appellants, my lord, gifted the property in the name of the appellants.
What is the relationship between the parties?
My lord, brother, own blood brother, my lord. But my lord, the writ petitioner is an allegation, and my lord, and a case has been pending before the Panchla PS with relates to the murder case, my lord, to the family members. That's why, my lord, mother excluded the writ petitioner from her property. That's why, my lord, the appellants is not a party in the writ petition, and my lord, the writ petitioner never approached to the brothers and also the mother to enter into the house.
Whether notice has been served on the writ petitioner?
In the writ petition?
Here.
Lordship.
Where is the affidavit of service?
No, my service has not been made. It is sent by speed post only yesterday, my lord.
All right. List the appeal under the same caption after completion of service of notice on the respondents,
Lordship,
along with the applications.
Lordship. My lord, appeal and with the two application, my lord. My lord, matter to appear, my lord.
It will come. You serve notice.
Lordship, Lordship. Grateful.
Next.
Serial number 15.
I appear for the appellant in this matter, but we are aggrieved. But we are aggrieved by an order dated 12th of February, where my lord, the writ petitioner has approached this honorable court, my lord, seeking a direction upon the bank, my lord, to refund, my lord, the consideration amount of the auction purchase with interest, with simple interest, my lord, for failing to hand over the physical possession of the property. Now, my lord, yes, but if your lordship, my lord, kindly takes up the order impugned before your lordship, my lord, I am placing the order before your lordship. Now, the petitioner is aggrieved by the act on the part of the bank in not refunding the sum deposited by him for purchasing a property on the auction under the provisions of the Services Act. The petitioner participated in the bidding process and was declared the highest bidder on 24th of August 2022. An upfront payment was made by the petitioner for participating in the bidding process. He deposited the balance consideration on 23rd of November 2022. The property, however, could not be handed over to the petitioner because of a litigation pending before the Learned Debts Recovery Tribunal, and an order of stay was passed by the tribunal restraining the bank from handing over the possession of the stressed asset. The petitioner accordingly requested the refund of the sale price paid by him by a communication dated 4th of December 2022. The petitioner has filed a supplementary affidavit in the court today annexing the communication of the bank dated 8th of August 2024, wherein the bank approved the refund request and agreed to pay the principal sum to the petitioner. The petitioner claims interest on account of the amount being withheld by the bank for a considerable period of time. Now, my lord, I am pausing here for a moment. But the order ultimately held, my lord, we have to pay back the amount with a simple interest. Now, my lord, we have sold the property.
The order says in the event the payment is not made within the stipulated time, then additional interest of 2% shall be paid. What is this? See, you agreed to refund the money.
Yes.
And you have been holding this money. Part payment was made in August 2022.
Yes.
Full payment was made in November 2022.
Yes.
He made a request because there was an interim order. You are not able to hand over possession of the property.
Yes.
You considered the request, rightly considered the request.
Considered the request.
When did you consider? That was in August 2024.
Yes.
You have been holding his money for all the reasonable orders.
Well, immediately, not immediately after the sale was conducted, the order was of stay was passed by the Debts Recovery Tribunal. Where
you should have vacated the order of stay immediately and approached the DRT and vacated the order of stay.
But we have taken steps. The writ petitioner is also a party, in that proceedings.
Sir, if they default in payment, will you not claim interest? You are a bank. You are a nationalized bank. You be reasonable. What is the simple rate of interest? Simple interest. What is the rate?
But 4% we have to pay. But there is no lacunae on the part of the bank. We are not deliberately holding back, not sitting on the payment. We are acting in terms of the order passed by the Debts Recovery Tribunal.
Where is the letter you agreed to repay the money?
Yes.
Page
71.
71.
This intra-court appeal by the Union
But
Bank
before
of
your
India.
lordship passes the order, may I place another?
No. This reasonable order. Intra-court appeal by the Union Bank of India is directed against the order dated 12/2/2025 in WPA 25571 of 2024. The respondent writ petitioner approached the learned writ court aggrieved by the act on the part of the appellant bank in not refunding the sum deposited by him for purchasing a property which was put up for auction under the provisions of the Services Act. Facts are full stop. Facts are not in dispute. The property which was put up for sale, put up for auction. No, sorry, strike that out. The writ petitioner participated in the auction sale and was confirmed as the successful bidder. Part payment was made during upfront payment was made after the appellant writ petitioner was declared as the highest bidder on 24th August 2022 and the balance was paid. Balance consideration was paid on 23rd November 2022. This is not in dispute. This is not disputed by the appellant bank. However, at the instance of the borrower, the debt recovery tribunal had granted an interim order, thereby restraining the appellant bank from handing over possession of the property which was put up for auction. Therefore, the writ petitioner made a prayer before the appellant bank to refund the entire sale consideration. Though such a request was made immediately after coming to know of the interim order granted by the debt recovery tribunal, the refund was approved only in August 2024. August 2024, as could be seen from the email sent by the appellant bank to the writ petitioner. The learned single bench therefore issued a direction to the appellant bank to refund the amount and also ordered that the amount should be refunded along with simple interest. This discretion was exercised by the learned writ court, taking into consideration that the entire amount, the entire consideration was paid by the writ petitioner as early as November 2022, and the bank was holding on to the appellant's money, writ petitioner's money, and the writ petitioner is put to prejudice on account of the order of stay granted by the debt recovery tribunal, which the appellant bank was unable to vacate. Full stop. Therefore, the discretion exercised by the learned writ court to direct payment of the entire consideration together with simple interest cannot be faulted, nor it can be stated to be an arbitrary exercise for this court to interfere. Therefore, we find no grounds to interfere with the impugned order. Accordingly, the appeal stands dismissed. The appellant bank is directed to refund the principal amount, the entire consideration, along with simple interest at 4% per annum within a period of 15 days from the date of receipt of the server copy of this order. In the event the direction is not complied with, and the refund is delayed, as ordered by the learned writ court, an additional interest of 2% shall be paid to the writ petitioner on and from the due date till the date of actual payment.
Look, the matter has been kept returnable before the learned single judge for compliance of the order.
So you can bring
yes,
this to the
and bring yes.
Next.
Real number 16.
My appeal.
Well, I am for the private respondents.
Private respondent.
Authority. My lord, I am for the private respondent number 9 and 10.
My appeal, Malad.
Sure. So where is the certified copy?
Certified copy. We had taken leave. I'm told we had taken leave from your lordships yesterday.
No, subject to condition you filed. You have not filed it.
Malad, only the server copy is available. We applied for it, and we've taken that leave from your lordship.
What is the writ petition?
Yes, Malad, I'll tell your lordship. Malad, ESI floats a tender for award of a work to whoever participates and is successful. ESIC, which is State Industrial Corporation. UPSIC is awarded the tender. UPSIC can do the work by themselves, or they can appoint a contractor to do that. Now, in this entire thing, the GFR guidelines are made applicable. UPSIC floats a tender, but restricts the scope of participation to tenders who are only from Uttar Pradesh and not to any other place. This particular clause we challenge because the two petitioners who wanted to participate, who are engaged in this and otherwise meets all the eligibility criteria, they can't participate because the clause is restrictive to participation. But the learned single judge holds that this is UPSIC's tender. Had they done it by themselves, then I would not have had a cause. Just because they floated a tender, I can't have a grievance, and therefore the petition has been dismissed. But
the main relief is against the respondents 3 to 6. They are outside the jurisdiction of this court.
No, that would the work is to be executed here. That probably I'll be able to satisfy your lordship on 226(2) because I am within. Part cause of action would have arisen within.
Your place of business
is within Milan.
It is within the jurisdiction of this court.
And if your lordship looks at
work also may be executed, may be executable within the state of West Bengal.
Within the state of West Bengal.
But the tender inviting authority, you participate in the tender which was floated by an authority who's outside the state.
Yes, but the main tender, which has to be executed by UPSIC or its contractor, is at page 47, which is by the authority in Calcutta. So my primary grievance is that when ESIC floats the tender, they enter into a memorandum of understanding which makes GFR rules mandatory. GFR rules say that you have to make an open tender and you can't have a restrictive clause.
No, but who are we to read?
No,
He's a tender inviting authority.
I'll indicate. I'll just show those two
he
guidelines.
wants people who are registered in the Uttar Pradesh Small Industries Corporation.
Yes.
Kanpur will be eligible. They want that.
They want that. Now, this clause I'm challenging on the ground that this is a public work that is to be executed, and there can't be a clause in a contract which is restrictive of participation, and there is no intelligible differential between now restricting it only to people in Uttar Pradesh. But the work.
But who are we to say that?
But I'll just indicate one thing. But I probably will be able to exemplify that the GFR guidelines or the notification is mandatory here. This tender has been restricted in its scope contrary to the GFR guidelines. If I can show that,
please show.
Yes, kindly have a look at two documents, Milord. Milord, if your lordship looks at page 135, which is the memorandum of understanding. I'll show one more clause. This is the memorandum of understanding between the tender floating authority, ESI, and this UPSIC. Kindly have a look at clause 1 at page 135. The work shall be executed on the following terms and conditions. The work shall be executed by government agencies on deposit work basis in accordance with the GFR norms. This is the MOU which allows them to employ contractors. There's one more clause that I'll just show. Lord, your lordship will just have a look at page 61. GFR guidelines. Page 61. This is in the parent contract between ESIC's tender. Page 61, clause 6.1. The last sentence. Agency has to follow GFR/CVC guidelines for awarding or selection of the work to contractors if the work is not executed by them departmentally. So GFR guidelines have to be. Now GFR guidelines, if your lordship has a look at, these are two copies.
Second page. Open tender.
Kindly have a look at clause 3.5 is mode of tendering and 3.5.1. In an open tender inquiry, which is what UPSIC floats, an attempt is made to attract the widest possible competition by publishing the NIT simultaneously on the designated websites and in the press. This is in the default mode of procurement and give the best value of money, but the procedure is relatively complex and prolonged, the systematic requirement so and so. So, and if your lordship looks at II-A, participation should not be restricted to only bidders enlisted with the procuring entity. Bidders already enlisted are also free to participate. However, requirement that successful unenlisted bidders have to get enlisted with the procuring entity before contract is placed on them. GFR 2017 makes it mandatory for all ministry departments of the central government, their attached and subordinate officers and autonomous statutory bodies to publish the tender inquiries, corrigenda thereupon, and details of bid awards on the central public procurement portal, and has dispensed with an organization. So basically, my lord, it is clear that it has to be an open inquiry.
Even this condition, II-A, says that at the time when the bidders participate, they may not, you don't insist upon them to be registered.
Yes.
But in the event the bidders get enlisted with the procuring agency, they should be enlisted. Successful unenlisted bidders should get themselves enlisted.
So here, my lord, that's the thing. So if once I participate, if your lordship looks at the report that initially we had been granted a stay, If your lordship looks at the report by UPSIC at page 80, their entire, which is why I say there is no basis on which they've come up with. They say that in terms of my rules and regulations, I can't do it. That is at page 81. But the rules we've annexed. So their case is to restrict. They say at 81, UPSIC has its own rules and regulations, which provides that only after enlistment with this organization. So this is directly contrary to the JFR guidelines. The contractors would be entitled to take part in any tender process. Apropos what has fallen from your lordship. If I participate, so it can't be restricted only to enlisted. If I participate, then I can get myself enlisted with UPSIC. But this reading is also, in my respectful submission, incorrect. Page 150, na? 151. If your lordship looks at page 151, we've annexed this. Regulation. We've annexed this regulation, the so-called regulation that they rely on. This is a part of my exception to that report.
Page 150 starts from 151.
It starts at 151. But if your lordship just looks at, kindly have a look at 152. These are the rules for certificate of enlistment of contractors. May I, Madam? 152. Kindly have a look at the second paragraph.
Yes.
Contractor enlisted under any class shall be permitted to tender in UPSIC Limited. Please mark the next three words, my lord. Anywhere in Uttar Pradesh for category of work that they are enlisted. So if my reading is that if the work is in Uttar Pradesh, then people who are enlisted with UPSIC are to participate in this tender. So this reliance on this clause or these rules, I don't think really furthers their interest here. Apart from it being absolutely contrary to 2A, what your lordship rightly pointed out, because it can't be restricted only to enlisted contractors. And time and again, your lordships have held that when it comes to public procurement, public related maintenance service, then it has to be a wide participation. But to restrict it only to...
The thing is, you have not been shut out.
I have been.
No, you have not been shut out. The precondition was enlistment. Enlistment may be for various reasons. So there may be a category by which they do an evaluation as to who will be entitled to be enlisted. So it is for the tender inviting authority. He feels safe that if a contractor is enlisted with him, and the tender is restricted to it, he feels safe that way.
Well, it is this safety that your lordships have pointed out in 2AII. That you can't restrict it on this restricting
what is the stage of the tender?
Lord, we've not been able to participate at all because we were not.
But work order has already been issued.
You are appearing for?
We are for the tendering authority.
Tendering authority.
Sorry, work order has already been issued.
But why have you restricted it only to UP people?
My lord, we kindly come to page 152, which my learned friend my lord relied. Rule 3, we made it open for all for enlistment.
Enlistment to all classes will be open to all individuals.
They didn't take any step to get them my lord enlisted. We have to provide this service to the ESI hospitals. So we need some authenticity. So ESI, for ESI my lord establishment, we have to provide the maintenance work on and from my lord 1st of April. Now in between my lord, they didn't take any step to get themselves my lord enlisted. Rather they challenged the entire process. After the selection, after the tender process was initiated, and everything was complete. By that time, they obtained stay order. Ultimately, that has been dismissed. Now we have already issued our work order to the other persons who have.
I am applying for the ESI authority, lordship. There is no restriction in the tender which have floated initially, so nobody can participate in the tender. There is no such restriction. And because of this litigation, lordship, our work orders maintenance is being stalled, lordship, because there are several hospitals which are to be taken care of.
Lord, may I just indicate one thing? Could I just respond to that in 2 minutes? Lord, this assertion that is made, that it's open to people anywhere in the country to have themselves enlisted is probably incorrect. 152 clearly states, contractor enlisted under any class shall be permitted to tender in UPSIC anywhere in Uttar Pradesh. Lord, I have to be from Uttar Pradesh to have myself enlisted here. No. That is the tender condition. If your lordship sees this tender...
No. Shall be permitted to tender in UPSIC.
Lord, may I just show the clause which is offensive, which we had challenged. Lord, it starts at page 47. 66. Kindly have a look at page 71. Kindly have a look at page 71.
Clause 2.
Yes, clause 2. This invitation for bids is open to all bidders registered in UPSIC Limited Kanpur in relevant category as defined in appendix to ITB. So I have to be a part of or within Uttar Pradesh to have myself enlisted. And this requirement of me being
You can be anywhere, but you need to be registered with UPSIC in Kanpur under the relevant category.
Lord, even if I take that to be correct, because there are forms which might speak otherwise, but even if I don't trouble your lordship with this, when UPSIC gets into this tender with ESIC, they admit that GFR rules will apply. The GFR rules prohibits it to restrict it only to enlisted. So this condition that they impose that you have to first get yourself enlisted to participate is absolutely derogatory of the GFR guidelines. So this is a case where participation is requested or required from people who are in absolutely contravention of the GFR guidelines. To restrict it only to enlistment, I could have understood that I participate. And after I participate, I get myself enlisted. Then the safety valve that your lordship are considering, that would have sufficed. That you participate, but within participation, your lordship would have come across such tenders, my lord, that within participation, within 90 days, you have to get yourself enlisted with me. Then I could have come under 2 IIAB. But restricting it to only enlisted contractors is directly contrary to the GFR guidelines. This is my ground of challenge. This is a case where a contracting or a tendering authority is acting completely dehors the applicable guidelines here. This clause is offensive.
If the ESI itself had called for the tender,
yes, Manoj,
that's a different matter.
Yes.
They floated a tender in which the UPSIC emerged to be the successful bidder. So now they have laid down a condition because they have to ensure that the work is performed to the satisfaction. They impose a condition that we will permit people who are registered with us or enlisted with us to participate in the tender, irrespective of any geographical restriction. So if that, how do you say it is illogical or irrational? Or
I say only two things. I say only two things. One is these guidelines have been made applicable in choosing contractors by UPSIC also in the memorandum of understanding that UPSIC has entered into with ESIC. That I showed to your lordship, which I can just draw your lordship's attention again to that, which is at page 158. And this entire tendering process, unless the tendering process authorized UPSIC to have the job executed through a contractor, UPSIC cannot do it through a contractor. Mindful of the situation, GFR guidelines have been made applicable. Because UPSIC or any successful authority, when it's getting its work done through a contractor, has to also follow. But otherwise, UPSIC or the successful tendering person, the bidder would not be entitled to get it done through a contractor. I'm sorry, they would have had to do it by themselves. His authority to get it done through a contractor is flowing from the main tender itself, which makes GFR applicable. GFR is also therefore made applicable to this MOU. If your lordship looks at page 158, I'm sorry, my lord. The 145.
35. GFR.
135. The page number again. 135. Sorry, my lord, 135.
One.
135.
Yes.
The clause 1. The work shall be executed by government agencies on deposit work basis in accordance with GFR norms.
CVC guidelines.
CVC guidelines, so and so. Standards, engineering, also observing due diligence in all respects. And if I may just trouble your lordship once more, my lord, if your lordship comes back to that clause which allows through contractor only at page 61. Well, this is a condition precedent for them to appoint a contractor to do the job. If your lordship comes back to 61, well, this is the first thing that I had to ask myself also, that they could have done it by themselves. 6.1, last sentence. Agency has to follow the GFR/CVC guidelines for awarding or selection of the work to contractors. So the parent contract, which allows them to have the work done through a contractor, applies these GFR guidelines. So basically, when you're choosing GFR guidelines, you have to keep it open and you can't restrict it to enlisted clauses. What
is your response on this?
If my learned friend will kindly supply a copy of the GFR to me at present, because
But in any event, what to do
this
now?
is the manual for
this
is procurement manual.
the work order must have been
This
an
is
extreme
procurement
undue
manual,
haste.
Mark.
19th of February, there was an interim order.
No, the process was completed prior to that, my lord. Only the work order issuance that was.
But then this is of utmost importance.
Well, I absolutely don't have a. Well,
So
the fact
ESA
also
hospitals,
remains.
and you by stalling the process that
No, I don't want the
Manual for
process to be stalled.
procurement of works.
Yeah, that is the GFR guidelines 2017.
No. This is manual for procurement of works. This is not the GFR.
This is manual for procurement by the government of India.
Yes. GFR is something else, my lord.
No.
Government finance rules. Procurement manual is something else.
This intra-court appeal by the writ petitioner is directed
Look, this
against
is
order
the GFR
dated
guideline.
19/2/2025 in WPA 3071 of 2024. The writ petition was filed challenging a notice inviting tender floated by the UP Small Industries Corporation Limited, which emerged as a successful tender in a tender invited by the Employee State Insurance Corporation for annual repairing and maintenance of civil and electrical works and special repair works of all buildings under the control of ESI Employee State Insurance Corporation, Kolkata, West Bengal, Sikkim region for a period of 1 year. The appellant's contention is that the restriction imposed by UPSIC in the tender document, in the bid document, restricting the participation only to those bidders who are enlisted with the corporation is illegal and contrary to the GFR guidelines. It is submitted that in terms of the GFR guidelines, all bidders should be permitted to participate in the tender, and such restriction is contrary to the terms and conditions of the GFR guidelines. Admittedly, the UPSC is the authority, UPSICL is the authority which had invited the tender. And it is for the tender inviting authority to lay down the terms and conditions of tender so as to ensure that the work which is to be allotted to the successful bidder is performed to its satisfaction. Therefore, the UPSICL had stated that enlistment of the contractor with the corporation is mandatory. This condition is pursuant to a rule which has been framed, which also stood amended subsequently, which specifically states that the contractors enlisted under any class shall be permitted to tender in UPSIC Limited anywhere in Uttar Pradesh for the category of works that they are enlisted. As long as the rule remains intact, the question of rendering any condition in the notice inviting tender issued by the UPSICL cannot be termed to be arbitrary or illogical or irrational. In any event, it is for the tender inviting authority to stipulate conditions in the tender document, And it is not for the court exercising jurisdiction under Article 226 of the Constitution to interpret in terms of interpret the terms and conditions of the notice inviting tender. And the only exception which has been carved out was carved out by various decisions is that when the tender has been so tailor-made so as to favor a particular bidder, which is not the case before us. Therefore, we are of the view that apart, the tender process, even at the time when the writ petition was filed, it is stated that the tender process was completed and it was at the stage of issuing the work order. And after the dismissal of the writ petition, the work order has been issued. Thus, for all the above reasons, we find no good grounds to interfere with the order impugned. Sorry.
Extremely grateful.
Grateful. Next. Let her lordship go through this 21-5 order.
Yes.
Sorry. সেটাই আমিও জিজ্ঞেস করি আছে কোথায়
Yes, sir.
But there's an application with by us which perhaps should be taken up first. There was a direction by your lordship asking the railway authorities to file a report. They've done that. We filed an application taking exception to the report. So that exception application,
Affidavit of railway respondent,
which is can 2.
Can 2.
Yes, the lordship takes up can 2 first.
My lord, the 21st May order, my lord, your lordships kindly have a look.
And you remove this from the tag. Very difficult to handle. Affidavit of competency and all will not required. Slowly.
Application for it?
Application can 2.
আমার তো খালি exception, can two sub করেছে?
Opposition reply.
That is.
Opposition reply show it.
The prayer is exception to be taken to the report.
Yes. But if your lordship would first take the order of 21st of May, by which they were asked to file a report.
No, what is the prayer? I'm not able to follow.
Lord, I'm sorry.
No, what is the prayer?
The prayer is not, we are taking objection to the report filed by them pursuant to your lordship's order. Lord.
Yes, that can be allowed. That exception can be brought on record.
No, that's no objection with my lord. I'm just pointing.
I'm challenging the report, Lord. I'm challenging.
My lord,
yes.
My lord, kindly have a look at your lordship's order, my lord, of 21st of May, 2024. My lord, paragraph 4 only. My lord, this is, it appears that the writ petition was disposed of without calling for affidavits. More particularly, the stand taken by the railway administration was not put in writing. The question would be whether a permission which stood lapsed in 2017 could have been revived by the Railway Administration respectively? And if so, retrospectively, and if so, what would be the position of persons who had acquired certain rights in the interregnum? This is one of the issues, my lord, which is involved, my lord, in this appeal. Apart from that, the court should be informed as to whether there was any technical assessment done by the Railway Administration before revival of permission to take the pipeline above the railway underpass, which has been permitted to be constructed by the writ petitioner when the permission for the pipeline was not invoked. This is the report, my lord. Whether there was a technical assessment or not, my lord, is what has been filed. My learned friend, my lord, challenges that report. So, my lord, your lordships want to, my lord, hear that first or along with the appeal? I have no objection.
No, we'll hear it along with the appeal.
My lord,
Very.
So the grounds of challenge is there in Can 2.
Yes. Yes.
We have understood.
And not all the parties have filed their affidavits to that Can 2. So
no, not us, my lord. They have.
no, the
That's
railways.
between
The
railways and
railways.
them, my lord, the exception.
Railway has filed it.
Yes.
And they have filed an exception in the form of an application.
And my lord, railways have dealt with that objection.
And they have filed an affidavit in opposition to Can 2.
Correct.
Correct?
Correct.
Yes. And we have filed a reply to that.
Rejoinder, reply, sir, rejoinder. Yes, sir. Please.
My lord, may I just, my lord, indicate to your lordships, my lord? My lord, the writ petition, my lord, was filed, my lord, by Mr. Bachawat's client, my lord, challenging, my lord, communication, my lord, of, my lord, 3rd of April, 2024, and, my lord, 4th of April, 2024, my lord, which had been issued, my lord, in favor of, my lord, my clients, who's the respondent number 6 in the writ petition and the appellant before your lordship. My lord, granting us, my lord, way-leave permission for, my lord, an underground pipeline, my lord, which had, my lord, 2 portions which were above ground. My lord, exact, my lord, my lord, exact, my lord, 1 minute. My lord, exact, my lord, my lord, of my lord, 2.25 kilometers, my lord, of the pipeline. The total length of the pipeline, my lord, is 2.25 kilometers. My lord, a total of 38 meters, my lord, was above ground, which is, my lord, approximately 1.68% of the total length of the pipeline. My lord, there are, my lord, 2, my lord, overhead, my lord,
yes, sir.
my lord, 2, my lord, areas where the pipeline, my lord, is overhead. My lord, one is of a 10-meter span, and another is, my lord, an 18-meter span. So, my lord, totally 38, my lord, meters. And, my lord, these are, my lord, going over, my lord, the underpass, for which, my lord, way-leave permission had been given, my lord, to the railway authorities, by the railway authorities to, my lord, Mr. Bachawat's, my lord, clients. Now, my lord,
Going over means across.
yes. So, my lord, I have a model. My lord, I have a model. My lord, I prepared that so that, my lord, is my lord. What is this?
This one, no?
My lord, no, my lord. I think it's, my lord, 3-dimensional, my lord.
Oh,
interesting. First time exhibit like this.
So, my lord, understanding is, my lord, important. My lord, I think, my lord, as to what is happening.
Very interesting exhibit.
Very nicely done.
Now, my lord, the underpass, my lord, your lordship sees, my lord, is in yellow. My lord, the trucks, etc., my lord, go under this, yes. Now, my lord, the yellow bit, my lord, has, my lord, walls, my lord, which are, my lord, there. Now, my lord, my lord, these are the 2 locations, but, my lord, that is, my lord, really the structure.
We'll come to that later.
Now, my lord, The, my lord, pipeline to the extent, my lord, it is overhead. My lord,
No, until this line, it comes under.
correct, correct. It's all underground.
And climbs up. on
Correct.
top.
Now, my lord, this overhead, my lord, is to protect, my lord, the underpass. My lord, originally it
No,
was
this is-
underground.
No, this is the railway bridge.
No, this is, my lord, support which we provide so that it does not rest, my lord, on the underpass. My lord, my lord,
And this gray pillars were constructed by the appellant.
correct, my lord, and it's 2.5 meters away from the wall.
The yellow is the wall of the
Correct.
underpass. Correct. And adjoining the wall, you put up two big
My lord,
pillars.
2.5 meters away.
All right. 2.5 meters away, you put up two big pillars.
Yes, ma'am.
On top of it, you have put up some.
My lord, on top of that, the pipe goes, my lord, and my lord, it rests, my lord, on that picture which your lordship has, my lord, the picture, my lord, that is the support.
The steel structure.
Correct. So, my lord, it is not, my lord, on, my lord, the, my lord, underpass resting on that. It is, my lord, 500 millimeters, that's half a meter above the ground. My lord, the support. So, my lord, it's not, and it rests on the two pillars.
This steel structure does not rest on the.
No,
underpass.
no.
And it is resting on two pillars.
Two pillars which are underground and 2.5 meters away, my lord, from the walls.
Okay.
My lord, this is, my lord, my lord, position.
But I don't want to interrupt my learned friend, but there is nothing over there at the moment. What they've done are these pillars. After that, Lord, we have come in, Lord.
No, 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 no. This was a photograph shown to court also. Right?
No, this photograph was.
Yes, it's there to show to court.
I see. Very well.
My lord, this is how it is, my lord. Kindly have a look.
Let's see. Two photographs are there. This one and this.
Yes. So, my lord, this is the position. My lord, two pillars, my lord, earlier, my lord, are pipes. Earlier, my lord, the pipes, my lord, were underground. My lord, we had a way-leave permission, my lord, in 2010, 2007, for a period of 10 years till 2017. My lord, this company, my lord, closed, my lord, in 2010. My lord, a CIRP revival process, my lord, was started, my lord, in 2018. During that period, my lord, Mr. Bachawat's client, my lord, applied for way-leave permission for, my lord, access to their factory, my lord, the trucks to have access over railway land, through railway land. So, my lord, they were given way-leave permission, my lord, to go underground. My lord, and that your lordships will find, my lord, from here. My lord, there are two of them.
Blue land, the land of Orissa Metallics.
Could I have a look at the other model in the meantime?
My lord, there are two spans. One is, my lord, one is, my lord, 10 meters, one is 18 meter span. Ten and 18. 10 and 18, totally, my lord, 38 meters. 2.5, 2.5.
So this is the writ petitioner. Orissa Metal Links is the writ petitioner.
Yes. Yes.
Ramsurup Industries is the appellant.
Correct.
And what does this depict? When
My lord, the two places where we have, my lord, the pipeline,
Yes.
that and on the other side.
And here.
Yes. Those are, my lord, the pipes.
And this underpass goes here.
True, correct.
The land of Orissa
And
Metallics.
here there is no underpass.
No, my lord, and that is, my lord, blue is the land of Orissa Metallics, my lord.
Both places.
Both places, yes.
Yes.
So they go under the railway. And your pipeline goes above in this
Yes.
area.
Yes.
What about this area? That's not in dispute.
Same thing.
My lord, two underpasses, but
Oh,
my,
two underpasses.
yes.
But this is in the,
Yes, that should not be affecting them at all.
because their land is here. and
Correct,
here.
correct. That should not be affecting.
The disputed area is this.
Beg your lordships.
The area in dispute is this.
Correct, correct. No, and they've objected to that also.
Oh, that
So, my lord, a person aggrieved situation will also come, my lord. I want to, my lord, argue that also.
Could I, Lord, look at this model, my lord, the other one, not
Yes, you showed both the module. This and this. You showed
But
both.
I'm now a little scared to take it because now he'll treat it like a toy, my lord. Mr. Jishnu Chaudhary is dangerous.
My lord, many of us have a fascination for Meccano and Lego. My lord, many.
No, those days it was
Already
it was Matchbox series. Those toys, no?
Yes.
Matchbox.
Yes, yes,
Matchbox
correct,
series.
correct.
Yes.
And they were molded toys.
Correct.
Most of them were hand painted.
Yes.
I had a collection of almost 70, more than 70. Because I was spending too much of time on that, my father threw away everything. Now they say it's a collector's
item. My lord, in fact, my lord, one of my juniors who's now settled in London, my lord, is doing very well. My lord is a partner of one of the large law firms there. My lord, he has, my lord, 2 rooms dedicated
for this
to Lego and, my lord, board games.
board games.
My lord, that's all that he does over a weekend. And my lord, Lego latest, my lord, product is, my lord, he's, my lord, one of the first to get it directly from Lego. My lord, like here, my lord, Mr. Banerjee, my lord, whenever there is a new Mercedes edition, my lord, he is informed.
Rightly said, rightly.
We're still talking about
And,
matchbox cars, Malad. We're still talking about matchbox
My
cars.
lord, that was many years ago.
Not the ones which
And
is-
Mr. Milan Mukherjee for this Mont Blanc.
Yes, possible.
Any new edition comes,
Yes.
he's here. Suddenly you will say, I want to meet you. They say, sir, this is a collector's item. Only 30 pieces were made in the world. I got one. And one is with ink, the other one is a ballpoint. He showed me one.
My lord, another person keeps quiet about it. My lord, Mr. Banerjee.
No, this I can't say.
Let me look
He
in
has
your
got a
pocket.
collection of more than 50.
But look at him covering his pocket, my lord. The moment this happened, he went like this. My lord.
I think he's got a collection of more than 50. Probably
Yes,
Banerjee, I don't know. how
Possible.
many.
No, Malad, I.
49.
Malad, matchbox Mercedes and Malad, lesser pens. That's all, Malad.
Lord, before these Matchbox cars became available in India, when we were younger, they used to have the Indian version of it called Dinky Toys.
Dinky toys. Yes. I also had that. And earlier, there is the oil company was, there is a Caltex. You remember?
Yes, yes.
Caltex always had a small
oil tank
store
Models.
in which they will have these small oil tankers.
Correct.
With the chassis and the.
And they
Yes,
could open
could be
Malad,
open
and
Open up. Could open up. It had a star on it.
My lord, all that's, my lord.
But those
Now,
were,
my lord, it's all electronic.
but whole afternoons were spent not playing with those and acting like we were bus drivers and conductors.
Yes.
Now, my lord, this is, my lord, the, my lord, position. Now, my lord,
They challenged the permissions dated 3rd April and 4th April.
yes. My lord, which, my lord, gave me, my lord, this permission. I'll place those 2 letters. Now, my lord, what is important, my lord, is, my lord, the admitted facts. My lord, 2007, as I said, my lord, my client, my lord, had, my lord, Whaley permission, my lord, for, my lord, an underground pipeline leading to their factory. My lord, in, my lord, it was for 10 years.
No.
Till 2017. Till 2017. My lord, in 2010, my lord, we closed down.
Yes.
My lord, while it had closed down, my lord, in 2019 and, my lord, 2022, my lord, Whaley permissions were obtained, my lord, by, my lord, the writ petitioner for, my lord, underpass. Whaley permission, my lord, for underpass, which was granted, my lord, on certain terms and conditions by the railway authorities. Now, my lord, in CIRP process, my lord, started, my lord, in 2018, my lord, as far as we are concerned. My lord, the resolution applicants was the present management, my lord, of, my lord, the appellant, those who, my lord, took over. And, my lord, the respondent number 6. Respondent number 6, my lord, proved to be unsuccessful.
Respondent number 6,
Sorry, my lord, the writ petition of my lord proved to be unsuccessful. In fact, my lord, there are documents on record to suggest that, my lord, they also had an arrangement to the effect that, my lord, if the resolution process failed and, my lord, the company went to liquidation, there would be a buyer. There's, my lord, records to that effect. Anyway, my lord, that did not succeed. My lord, the present management, my lord, of, my lord, the appellant became the successful resolution applicant and took over, my lord, the appellant.
September 2019, sir. Resolution plan approved by NCLT.
My lord, in, my lord, September 2019, my lord, 4th September 2019, my lord, the resolution plan, my lord, was approved. Now, my lord, I am not going into validity of clauses or anything of the resolution plan. There were 2 clauses in the resolution plan which made us, who were bound by the resolution plan, to apply in a particular manner. My lord, the clauses, my lord, said that whatever permissions, my lord, were subsisting, my lord, permissions, consents, licenses, etc., my lord, in the name of, my lord, my lord, appellant, would, my lord, continue for a period of 1 year, my lord, and thereafter to be revalidated. And, my lord, it also contained a clause to the effect, my lord, I'm not going into validity. It was put into the resolution plan, my lord, and we, my lord, apply on that basis. My lord, which, my lord, said, my lord, that, my lord, on the closure date, if there was any consent, my lord, which was in existence, that would deem to, my lord, continue for another period of 1 year, and an application had to be made. So, my lord, what we did, my lord, was apply, my lord, immediately on, my lord, approval of the resolution plan, proceeding on the basis of these clauses, as if the license was still existing, for revival, for another period, my lord, of 10 years. My lord, that's, my lord, was what was, my lord, our application. My lord, considering, my lord, all that, my lord, now kindly have a look at those 2 documents, my lord, which were challenged. My lord, 3rd April, my lord, is at page 104. My lord, the subject, my lord, kindly see, 3rd April 2024, revival of way leave permission for municipality water line of 500 millimeter diameter already laid, 1.2 meter depth from average ground level from kilometer 119-18 near National Highway 6 to kilometer 121-2 under railway bridge number 139, and then cross the track along the waterway of bridge number 139 in on a concrete pedestal in expose up to GKL well number 3, then along NA line up to so-and-so, and then enter into Ram Sarup Industries Limited. Then reference your application dated so-and-so, Ram Sarup's letter dated so-and-so, bank guarantees dated so-and-so. In terms of sanction revised drawing, dated and detailed estimate bearing so-and-so, sanctioned by competent authority of both sides, you have deposited total amount of 2 crore so-and-so, VDA MR dated so-and-so, deposited at so-and-so, way leave charges, rupees 1 crore 79 lakhs so-and-so for 10 years from the year 2017-18 to 2026-27. The renewal of way leave permission for revival of pipeline is hereby issued in favor of Ram Sarup, along with Xerox copy of agreement and original money receipts for way leave permission for revival of 500 so-and-so under railway bridge, and then cross the track along so-and-so. Now kindly note, on concrete pedestal in exposed up to GKL and then along so-and-so, and then into Ram Sarup. The work will have to undertake as per drawing and design, completing all the formalities, kindly note this, with other departments of railway, if due, and in presence of railway engineers. The structural drawing and design at the subway location to be submitted with the approval of reputed organization before execution of work. Necessary permission to be taken from office of so-and-so before execution of work. In terms of the agreement and estimate, an amount of requisite way-leave charges revised as per Railway Board's guide from time to time has to be deposited with Railways towards annual way-leave charges from the year so-and-so onwards. In the event of failure to deposit, Railway will have full power to suspend permission. Then, my lord, comes, my lord, the fourth, my lord, April document at page 66. My lord, this is to inform that renewal of way-leave permission for revival of pipeline is hereby issued by competent authority. I'm sorry. Page, my lord, 66.
Printed page.
Yes, my lord, printed page, my lord. It's, my lord, from, my lord, the stay petition, my lord.
Yes. It is
My lord-
annexure P4, is it?
No.
I think Lordship is looking at the exception.
My lord, your lordship looking at the can, my lord, the
Can
stay
one.
petition.
Stay petition.
Stay petition, my lord, it's 120. I'm sorry, my lord, 120. 120. My lord, the franking, my lord, is, my lord, 120. 4th April, and my lord, 3rd April, my lord, was. My lord, 3rd April was at page 104, my lord. And my lord, this is, my lord, at page, my lord, 120.
Yes.
This is to inform you that renewal of way-leave permission for revival of pipeline is hereby issued by competent authority in favor of work will have to be undertaken as per drawing, completing all formalities with other departments of railway in presence of. The agency has intimated that they found some damage in pipeline from Jharia pump house to their plant, which needs repairs, and the repairing work will be started from so-and-so. So you are hereby requested to depute your competent supervisor on above scheduled date and then positively during so-and-so. This is, my lord, an internal communication, as your lordships, my lord, would have seen. My lord, of the railways. With, my lord, copy, my lord, given, my lord, to us. That's the last, my lord, copy to RIL, Ram Swarup Industries. My lord, these were, my lord, the subject matter of challenge. And, my lord, there was a prayer, my lord, that no further work should be undertaken, my lord, for, my lord, this underground pipeline. These were the two prayers, my lord, in the writ petition, which your lordships, my lord, will find, my lord, at page, my lord, 69. My lord, kindly see, my lord, prayer B, writ of in the nature of mandamus commanding to withdraw, recall so-and-so, dated 3rd April, and the letter bearing so-and-so, dated 4th April. Then, my lord, a writ of in the nature of prohibition to issue restraining from permitting revival or permitting use of pipeline, and respondent number 6 from reviving, repairing, and making pipeline. Now, my lord, principally, my lord, there were 4 grounds of challenge. My lord, first is, my lord, there is a railway code, my lord, 1033. The ground of challenge, my lord, was, my lord, that, my lord, 1033, my lord, clause 10, my lord, 1033, subclause 3, subclause Roman 2, my lord, had been, my lord, violated by, my lord, the railway authorities. And, my lord, the second was that, my lord, of that same code, 103312, my lord, had been, my lord, violated. My lord, basically, in short, the objection was the railway code did not permit, my lord, any new construction, my lord, which was, my lord, overhead. Therefore, it could not happen. And second, my lord, was the source of water supply need not be the municipality, but, my lord, could be from the Kongshaboti river. And therefore, my lord, there was no need to grant way leave permission. These were, my lord, two grounds, my lord, which had been taken on the basis of the railway code. Now, my lord, second was, my lord, third, my lord. Third was, my lord, this was contrary to, my lord, the master circular of 4th of October 2022. My lord, according to the writ petitioner, my lord, a renewal could, my lord, only be given, my lord, of a way leave permission if, my lord, it was subsisting as on the date of the master circular of 4th October 2022. And their case was, this way leave permission had, my lord, already expired, which was in favor of my clients, the appellants, in, my lord, 2017. So, my lord, there was no question of renewal, my lord, of, my lord, this way leave, my lord, permission. Fourth, my lord, contention, my lord, which was raised, my lord, was that, my lord, there could not be, my lord, a revival of, my lord, a way leave permission which had generally, which had, my lord, expired, particularly when the revival would cause prejudice to rights which had become vested in the respondent number 6. Not yes, respond number 6. Oh, my lord, I don't know. Respond number 1, the writ petitioner, my lord. The respondent number 1, by virtue of, my lord, the way leave permissions which had been granted to them. And these are broadly, my lord, I'm indicating. And lastly, my lord, there could be, my lord, no, my lord, grounds. My lord, the order will, my lord, show. And lastly, my lord, their case was, my lord, that, my lord, before the design approval, my lord, of, my lord, the overhead, my lord, pipeline, way leave permission had been granted, which could not have been done. These were, my lord, the grounds, my lord, which had, my lord, been, my lord, taken. My lord, no affidavits had been filed in this matter. My lord, the matter, my lord, was argued, my lord, at length, both by the railways and, my lord, my clients, who were the respondent number 6 before the learned judge. My lord, our specific case was, my lord, firstly, my lord, that, my lord, the writ petitioner could not maintain, my lord, the writ petition for the simple reason that it was not, my lord, a party aggrieved. Now, why did we say so? My lord, our case was that, my lord, the approval which had been granted was based on a technical assessment which would show, my lord, that there was no damage being caused, my lord, to, my lord, the way leave permission or the, my lord, the underbridge, my lord, which they had constructed. Second, my lord, they had, my lord, failed to show, my lord, how, my lord, there would be a damage. And, my lord, in this connection, we had produced the technical drawings. My lord, this was number 1. So, my lord, if they couldn't show, my lord, any, my lord, damage, my lord, they could not, my lord, maintain the writ. Secondly, my lord, our case and of the railway was, my lord, the wayleave permission, my lord, which had been granted to them. Even on the express terms of these wayleave permissions and the agreement which they had executed with the railways, did not give them any right, title, or interest in the land. None at all. It was merely, my lord, a wayleave permission, which was in fact on a lower level than a bare license. Third, my lord, that, my lord, neither the master circular nor the railway court, my lord, imposed an absolute bar on the face of it to, my lord, approve, my lord, wayleave permission for, in effect, my lord, and I say in effect, a underground pipeline, which, my lord, to protect their underground bridges, only had a 35-meter span, a total of 38-meter span, my lord, overhead. It was in effect an underground pipeline because, my lord, it was 2.25 kilometers. My lord, 1.68% was overground, and that too to ensure that their underbridge wasn't affected. Though, my lord, my old pipelines are still lying there. Though their case says, my lord, that they have damaged, my lord, my pipelines, and their agreement says if they damage, they have to pay, but they have not done it. They were aware, my lord, that this was there. And, my lord, lastly, we had argued that, my lord, my lord, writ petition itself, my lord, the petitioners hadn't come with clean hands. My lord, having been unsuccessful, my lord, as a resolution applicant to acquire, my lord, Ram Swarup, now, my lord, was, my lord, an attack from persons who, my lord, succeeded in the bidding war to acquire Ram Swarup. And, my lord, which in effect renders, my lord, the resolution plan, my lord, almost meaningless. Because it was for revival, maximization of value, all payments made. Secured, my lord, financial creditors out of the way. I've taken over the workforce, but, my lord, I am not, my lord, getting, my lord, water to, my lord, run, my lord, the unit. Now, my lord, kindly have a look at the order, or we can continue on Monday, my lord.
Not on Monday, Wednesday.
Very well.
We have heard Mr. S.N. Mukherjee, learned senior advocate, appearing for the appellant for continuation of arguments, list on Wednesday under the same caption.
And, my lord, it will retain its position now because it's parted, my lord.
Just একবার বুঝে নিচ্ছি আমারটা মনে পড়ছে
I have removed all the thing from the tag. You have to re-tag it.
Wednesday তো
Oh, interesting.
Monday full day থাকে না কোনো বলা হয়ে গেছে
The models you can take.
Yeah.
Model.
Yes. My lord, we can leave it here, my lord. We'll bring it back, my lord, on that.
Yes, Vishnu wants to play with it.
I do conference with মডেলটা
হ্যাঁ একটা কপি দাও সব কপি
May I have my lord's kind leave to mention one matter, my lord? It's a customs appeal.
Hmm.
I'm mentioning this upon notice. I'm the respondent, my lord. The appeal was dismissed in June 2024. Thereafter, my lord, the matter came up before my lord. November 28, 2024, it has been restored. Delay condoned, and there was a specific direction that it will be heard on merit. Now, the matter didn't appear, my lord. We are suffering the bank guarantee, my lord.
We'll include.
Grateful, my lord.
Yes, Mr.
My lord, for yesterday's incidents,
No, your
my lord, I
colleague.
tender my unconditional apology.
No, your colleague did a good job.
But it was a very interesting matter. Your lordship has decided very important issues, my lord.
Actually, the problem is this Chhattisgarh officer is not within our jurisdiction. So therefore, slightly we have issued a
In
modified
fact, my lord,
direction.
I felt poorer, my lord, because I had drafted the petition, my lord. I thought I would be able to make it before your lordship, my lord. That,
So the sixth respondent will address a letter
my lord.
because it is an admitted fact of interstate sale. They are not able to issue C form because the seventh respondent didn't apply.
Because my lord, it's a statutory right under the Central Sales Tax Act. Nobody can be denied the benefit.
But then there's a procedural law as well. So that gap we have covered.
My lord.
Based on that communication, you apply to the Chhattisgarh officer, he will consider.
In fact, there are judgments of Madras High Court which has been affirmed by the Supreme Court. The very issue which your lordship has held, they have also.
No, in Ashok Leyland case, it has been clearly held. There's no.
I'm sorry, my lord.
My lords, may
Tanoy also agreed with that order.
Why?
He had no other option. Yes.
My lords, may I seek permission to mention a matter, my lords? My lords, in this matter, I am seeking for inclusion in the list, my lords. No, my lords, this matter was upon direction of my lords. It had been sent out of the list, my lords. There was a appeal filed by the commissionerate CGST, and there is an upon the instructions given by the appellant's counsel that there is an SLP pending.
No,
The
SLP
matter was put out of the list, but there is no pending SLP as of date, my lords. So, my lords,
Who appeared for the appellate
my
department?
lords, Mr. Maiti had appeared on the last occasion.
Where is
I have served on the other side, my lords, Mr. Bonjus.
But you verify?
Yes, my lord. Verify.
If no SLP is pending, then you argue.
Yes, my lord.
My lords,
You have verified that there is
we
no.
have verified it on multiple occasions, my lords. There is no such pending SLP against this matter.
You show that order.
Did you order to?
But in the grounds of appeal, they had said the SLP is pending.
Yes, indication is there. Therefore, my lord has.
That is why we recorded and put it out.
My lord, let the matter be listed, my lord. We'll argue.
Yes, my lords.
But you have to get written instruction.
Yes.
Anjan, can you show it in days list and pass a short order? Huh?
Let's let the matter be included in the list.
Wait. The matter is included in the days list under the caption to be mentioned. By order dated 28 June 2024, the appeal was directed to go out of the list on the ground that a special petition has been filed before the Honorable Supreme Court against the decision of the tribunal in the assessee's own case reported in 2006 197 ELT 97 within bracket TRI-DAL bracket close. The learned advocate appearing for the respondent assessee submitted that thorough verification has been done by the respondent, and it transpires that no special petition is pending against the said decision in the assessee's own case. We have directed Mr. Tapan Banjal, learned advocate, standing counsel for the appellant, to take notice in this matter and get written instructions from the department as to whether an SLP is pending, and if so, the case number and other details. List the matter on so and so date. Based on this,
Yes, my lord.
Please call.
Original site daily list item number 1.
My lord, Mr. Kundale is appearing for the ED
This is for
But
dismissal.
nobody is appearing. I don't know why. None appears for the appellant. When did the matter come up? Yesterday it was listed, huh?
21st February. This is 21st.
On 21st February 2025, when the matter was listed, there was no appearance, and therefore the matter was directed to be listed today under the caption for dismissal. Today also there is no appearance. Thus, it appears that the appellant is not interested in prosecuting the matter. Hence, appeal is dismissed for non-prosecution. Next.
Item number 2.
My lord, I have not received the copy of memo of appeal. Only limitation is forwarded to me by one online.
We have served, my lord. The postal report says not delivered, door locked. But my lord, I have already, my lord, given the copy of the conditional deed application, my lord, by mail. And here is, my lord, 47 days.
Under section 5 is mailed to me, my lord. And if permitted, I will file the opposition.
47 days.
I don't know, sir. How much delay?
Yes.
We are saying 47 days. We can give.
But I have given already, my lord, mailed copy, my lord, given to my learned senior friend.
Copy is
That can be condoned, my lord. I have no objection to that.
All right. Delay we will condone.
Yes, yes.
So and so. Condone.
I'm grateful, man.
Item number 3.
Delay of 76 days.
No issues. Assessee says that she has not sold any shares during the assessment year under consideration.
CIT appeal nothing. Lord, this has been said, my lord, for the first time before the tribunal.
No, Lordship. I have said so before the assessing officer, and the evidence is there in the record, Lordship. Before the assessing officer as well as before the Commissioner Appeals, I have repeatedly taken a stand that I have not claimed any income exempt, Lordship.
How does the Commissioner?
Commissioner has not dealt with my submissions, Lordship. Kindly refer to page number 50 of the petition, Lordship. He has summarily rejected my submissions, even though I have made detailed submissions, Lordship. And the allegation and Lordship, the order on objection surprisingly records that I have earned income from immovable property under section 50C. This is the order on objections. Whereas the reassessment proceedings were initiated for the reason that I have earned capital gain, Lordship, which I have not, because I have produced before the assessing officer
Lord,
as
can
well
we
as.
take it on Friday, my lord, in case my lord, my learned friend is arguing it, my lord, because I thought, my lord, only delay will be condoned today, my lord. I'll come prepared on merits. But if my learned friend is placing the merits today, my lord.
No, Lord, no issue, Lordship. As your Lordship, please.
All right. You condone the delay. List the appeal next week. You give a copy of this.
I will, Lordship.
Delay condone.
Grateful, Lordship.
Item number 4.
My lord, there is a delay of 200 days, my lord, but the assessee, my lord, we have not been able to serve, my lord. It is said it cannot be located. 57 days.
Addressee cannot be located. Addressee cannot be located. So fresh email service returned back.
Lord, the envelope, my lord, has returned. The endorsement, my lord, assessee cannot be located.
Mr. Surana can take notice. Dev Bhumi in my private limited.
Dev Bhumi.
Page 61, you please show.
Page 61.
Page 61.
My lord, I am not yet briefed. I do not. My client might not have received.
He will brief you now.
Issue here.
We have heard so and so, so and so. We directed Mr. S.M. Sunana,
That appears to be less
an
than
advocate, to take notice in the matter and file wakalatnama. There is a delay of 57 days in filing the appeal. As the delay has been properly explained, the same is condoned, application allowed. List the appeal for admission on so and so date. Let the name of Mr. S.M. Surana be printed in the cost list. Appearing for the respondent, be printed.
Item number 5.
It 602 days. Smita, your opinion. Oh, assessee's appeal. Sorry.
Five.
Ours is 6.
आज 6 हम लोग का 6 नंबर है ना 5 चल रही है तो उसके बाद होगा ना
The appeal was dismissed following Swati Bajaj. Mr. Bhushan. Bhushan is a chartered accountant or a lawyer? Mr. B. Bhushan.
I've never.
Concurrent finding. All right. You find out who will appear for them. None appears for the appellant assessee list. So and so.
Item number 6.
And for the respondent.
There is a delay of 612 days, and I have a reasonable cause, my lord. The reason, my lord, why there is a delay is stated at page number 3 of my petition, para 3. May I read, my lord? The petitioner states that it had appointed one Sri S.L. Poddar, learned advocate, as authorized representative for filing the appeal and appearance before the Income Tax Tribunal, Kolkata. The petitioner states that Form 36 filed before the Income Tax Appellate Tribunal contained address, mobile number, phone number, and email address of S.L. Poddar. Your petitioner states that authorized representative Sri S.L. Poddar failed to appear before Income Tax Appellate in respect of the aforesaid case, nor did he give any information about the ex parte order passed on 10/2/23 by the tribunal. The petitioner also did not receive any copy of impugned order of ITAT Kolkata. Your petitioner states that it came to know in the last week of December 24 from a call from AO that the appeal had been dismissed by the tribunal. Then, my lord, he contacted me, and my lord, actually, the directors are based in Rajasthan, Jaipur, and they appointed this particular tax consultant, and he gave his address. in Form 36, which is at page 7, my lord.
But even before the tribunal, there was a law. From
1,500.
1,500 days delay.
And you see the conduct of the assessee.
My lord,
He has misbehaved with the caller,
my
the
lord,
bench clerk, and the office superintendent.
may I explain, my lord? I appointed the advocate,
You go to the
tax,
bar council.
the tax consultant, my lord. It is the misbehavior, and I am also suffering because of him. The,
So let him suffer. You file a complaint before the bar council.
my lord, kindly see the letterhead and Form 36. My lord, at page 30,
1,516 days.
my lord, tribunal has accepted 1,000 days delay. Only 500 days delay, they are saying that was not accepted.
Where is it accepted?
My lord,
Which paragraph?
my lord. Page number 63, my lord. From the middle, my lord. An effort was made to inform the assessee on the mobile numbers mentioned in the letterhead of SL Poddar. This is the mobile number of SL Poddar, not mine, as well as given in Form 36. But whosoever has picked up the phone, he misbehaved with caller.
With the caller. CALLER, caller. That is the bench clerk as well as
office superintendent. This oral conduct suggests that somebody is looking after filing appeal etc. in the court, but seriously not prosecuting the litigation. Therefore, we do not find any reason for condoning huge delay from February 2018 to March 20, after excluding the period of limitation of filing the appeal up to March 20, when COVID has struck in the country. As far as COVID period is concerned, we exclude that period from the limitation counted by the registry. But even if the exclusion of COVID period, the time appeal is barred by more than 500 days. Therefore, we do not deem it fit to condone the delay in filing this appeal. My lord, the affidavit has been reproduced in the body of the Honorable ITAT order at page 58. Wherein at para 2, the director is clearly saying that the appellate order passed by the learned CITA on 10th of January 2018 was never served upon us. The first time it came to our knowledge when I visited ITBA portal in first week of January 2021. And my lord, CIT appeals order, if we look at,
there also it is ex parte.
My lord, if you look at, he is serving, he is sending the notice, but there is no finding that it was served upon me.
No, nobody appeared even before the CIT appeals.
My lord, kindly see what he is saying in para 1. Para 1, last 2 lines, subsequently notices have been sent fixing hearing on such and such date, but no one attended, has been sent fixing hearing, but it was never served upon me. My lord, may I explain the background, my lord? My lord, I am based in, the directors are based in Rajasthan. They had taken over the company in 2014. And earlier the litigation was the share capital addition was there, and I was not aware. Later on, I came to know, and then I appointed Mr. Poddar. And my misfortune is that he is not representing me. And tribunal, my lord, could have served it.
Who appeared before the CIT appeals?
My lord, CIT appeal, this was filed in 2014, April 2014. My lord, at that time, there was change of management.
That change of management, you have to do your due diligence.
My lord, at so much of addition, my lord, 9-10 crores of addition.
My lord, at least even if it is to be sustained, at least I should be given opportunity of hearing, my lord. My lord, some
This
cost
is-
may be imposed.
See, had you contested the matter on merits before the CIT appeals, it may be one thing.
My lord, he is not even dealing on merit, because appellate authority, there are a number of decisions, my
No,
lord.
he has dealt with on merits. Maybe it's not a big judgment, but he has dealt with on merits. In fact, at page 36, he says, the appellant has filed the appeal, not taken care to avail of the opportunity of being heard. Hence, I have no option but to decide the appeal ex parte. Therefore, he proceeds.
But no whisper about the merit, whether share capital is bogus, why the AO has held it to be bogus. All these facts are not.
How much is the tax demanded?
My lord, it is a huge sum, my lord.
7 crores 32 lakhs 76,126.
My lord, may I be,
50% you pay.
my lord, may I be permitted
will
to
die.
place?
My lord has given a, in such situation, my lord has passed an order, and my lord, with some compassion, if it can be reduced.
No, when it comes to the department appeal, we don't even hear the assessee side. We dismiss it. If it is above 500 itself, it's gone.
My lord, this is a special case, and my lord,
The speciality is Mr. Subhash Agarwal is appeal.
not at all, my lord. My lord,
That
I
is the
am
only
myself,
speciality.
my lord, I am myself offering, my lord, what my lord has decided. It is a wonderful situation where everybody is winning. My
No,
learned friend will not oppose this order.
no, no. I will definitely oppose it. It's the discretion of my lords.
With some concession, if it can be done, my lord, I am agreeable to that.
50%.
50% of this amount, my lord, what my lord had.
7 crores.
My lord, I will die, my lord. That.
These fellows are passing the assessment orders, and every order is on paper. When the assessment was completed, 30th of April.
My lord kindly comes to page 26. Since the very inception, your lordship kindly see the conduct of the SSC. Paragraph 1.2 and 1.3. He has chosen not to comply. The proceedings of the assessment, my lord. He was asked to produce the relevant documents. He did not
I have
turn up.
filed para
Day by day,
1.3.
he has
Para
been given an
1.3 is
opportunity.
clear.
Ample
Only my
opportunities
director
were
did
given
not
to him,
appear
but he has not.
because this
1.2 and
assessment
1.3,
was done
my lord.
after 5 years. So directors and at the fag end,
He's
he
a habitual
asking.
defaulter, my lord. He doesn't
Not at
appear
all.
and he comes up with a plea that it should be condoned. He has not even appeared before
No, Mr. Ashok Jain, the chartered accountant appeared. Then another date was given.
Your lordship kindly
On that
sees-
date, they sought for adjournment.
Yes.
And on the adjourned date, nobody appeared.
But
and
there
no-
was no compliance, and the date of the hearing, even though both the notices were duly served on SSC by the
Documentary
postal-
evidences were filed. Only directors could not be produced because within 20 days, how can I produce? It is 7-8 years old matter. In the first round, we had AO did not make addition.
You pay substantial amount. We will send it back to the commissioner.
My lord, my demand will be there. They will be entitled to recover the entire amount.
Probably you are not traceable.
My lord, some compassion should
Some
be.
compassion
Natural justice should be given. I should be given up. My lord, tribunal.
We can't appreciate, sir. He is
My lord,
running away from-
tribunal could have served me directly.
What is the amount you will pay? 7.32 crores is the tax liability which accrued as early as in the year 2010.
My lord, I don't have wherewithal to pay so much of money. Even if my lord asks me to pay 10% or 5%, I will not be in a position to pay.
Then what to do? Then you just throw up your hands and get the company wound up.
My humble submission is that, my lord, on those lines.
We also, at times, I'll tell the court officer, you please see the docket. There will be some mobile number. You call them, the matter is listed.
My lord,
and he calls because we are saying the person who receives the call abuses him.
my lord, I am not responsible for it. My tax consultant is doing that.
Sir,
Lord,
he is your authorized representative.
my lord, what happens?
Once you give a wakalatnama, whatever misdeeds he does will
In
automatically.
ITAT, my lord, I had been practicing there for 20 years. The practice is that if notice is not served, it is served through department. My lord, they are.
All right. The respondents are directed to file their affidavit in opposition to the prayer for condonation of delay, which in our prime facie view is inordinate. Let such affidavit be filed within 2 weeks from date, 3 weeks from date.
3 weeks.
Reply, if any, within a week thereafter. Give a date after 4 weeks.
Deeply.
New application item number 7.
This was taken up last Wednesday, then the court had to rise at 3. Now, regarding that industrial furnace, Lordship, the bought out items, the taxability of bought out items in case of manufacture of
yes.
Bought out items, my lord, we were referring to some judgments also. Also, my lord, your lordship will kindly see the adjudication order where it has been held by the adjudicating authority
Brought out items are essential.
at page 28, 27, (5.3). The said noticee I find in their reply contended that cost of bought out items directly supplied to buyer's place for erection and commissioning cannot be included in the assessable value. Thereafter, the tribunal, after considering various orders, have been pleased to hold, I find is not squarely applicable. A manufacturer of industrial furnace and handling equipment system got the order of supplying and fixing the same.
Those bought out items have already suffered tax.
Well, that over
At
here,
the time when the vendor
Lordship will kindly come to page 28.
and
Well, I have found
Mr.
that.
Banerjee, there are several decisions of the tribunal.
Well, that is not his case before the lower authorities. That bought of items that has already suffered the incidence of tax. He's saying that
was his submission on the last.
no,
Lordship, that was my
over
submission.
here.
And
For
no,
the High
Lordship,
Court, he is making his submission.
No, not like that, Lordship. My
Lordship will
submission
kindly
was,
take-
Lordships,
My lord, for once, kindly, my lord takes it to 5.6. Though the noticee cited the above case laws, but I find that I find that in instant case, the noticee procured order for industrial furnace and handling equipment system in complete form so that it can start functioning. So the bought out item on which duty has not been paid is essential ingredients for completing of the machine, fulfillment of the orders procured by the said noticee. Now, it is to be whether the bought out items forms a part of the essential functioning of the entire machine is the subject matter of consideration before the adjudicating authority, which held that these are the essential criteria without which the equipment will not function.
This is central excess duties
Well,
liability.
that has been relied upon this mill and company. Well, Lordship will kindly see which has been relied upon. Kindly see the.
Where is the reply to the show cause notice?
Reply to the.
Well, it has been quoted in the adjudication
Commissioner's order.
order. It is at page
Page, they reply this submission, page 23.
page 23.
Did not file any reply.
But submission, they have given this.
Submission.
no, Lordship, during the course of personal hearing, actually, in earlier regime, when the show cause is issued, they give just 30 days. So at the time of personal hearing, we submit the reply.
Where is your extract of your reply?
Well, at page
They have taken
24
some
onwards.
parts in the personal hearing, page
24
24 onwards, they have taken the parts. In fact, Lordship, in the Sestet appeal paper book, it was a detailed reply which was annexed. And during the Sestet, Lordship, we had given this to compilation, which I handed over to my learned friend last occasion, wherein the certain judgments which were relied.
No, on this factual aspect.
Lordship, on the factual aspect, our case before both the authorities was that the excise duties on manufacture. This is the case of bought out items. So bought out items is what I'm trading. You cannot tax what I'm trading. Lordship, as I was explaining, that was my case. And before the Sestet also, we pleaded that what they're trying to tax is an immobile property. Lordship, when I take a contract of industrial furnace, I manufacture most of the parts in my factory. Now that has taken in SKD forms to the place where the industrial furnace has to be put in. Now various parts which I don't have the capacity to manufacture, I take it from other buyers. Now that he may be an excise manufacturer, he may have paid, I have got duty paid goods. Maybe he has paid VAT, he is also a dealer maybe. But Lordship, as I placed before Lordship last occasion, the department could have invoked service tax on me. Okay, on erection commissioning, you should have paid service tax. But what they did, they have due to charge excise duty and on an immovable property. Lordship, it is not in dispute that what they are trying to tax is not manufactured by me. And the whole concept of excise under Lordship section 2F is on manufacture and manufactured within my premises. If I manufacture something outside and it is not their case that I am manufacturing that, they have taken this Lordship from my balance sheet. In my balance sheet, there is a traded goods income. So that traded goods, they are in the expense side, traded goods is there. So they are taking that figure from trading and you have to pay excise duty. Lordship, the whole concept of manufacturing will fail in that case. And Lordship, in fact, in the compilation that we have relied upon before the tribunal, 2 judgments went up to the Supreme Court also, which the Supreme Court had upheld the judgments.
That Bombay Tribunal judgment.
Well, those are distinguishable, which
Lordships.
which signifies if what compilation has been forwarded to us, those are segregated. They say that it was sent directly to the buyers or the area. But over here, these were procured by him for the purpose of completion of the entire product.
No, they didn't manufacture those goods.
Yes, well, that is not, they have not pleaded in their reply, nor before the adjudicating authority that look, these bought out items have already suffered an incidence of tax, whereas the adjudicating authority has held.
If it is a bought out item, can it be included in the assessable value of
Well,
the
Mill
manufactured
India,
goods?
Mill India has said, well, for once, well, Para 2.5 for your lordship's kind consideration. We have indicated the paragraphs.
2 and 5. There are 2 and 5.
2 and 5.
ফোন করে আছে মামলা করতে দেখেন আমার কমপ্লেন হচ্ছে অস্থির হয়ে যাচ্ছে Exactly, Samani, it's a composite service. It is a composite contract.
You invoke the extended period of limitation.
Yes. It is extended.
Where is the suppression you have brought out in the show cause notice?
Well,
There is no allegation at all.
This.
Where is this allegation of suppression?
Well, it is in paragraph 2.3 of the adjudication order.
No, show cause notice.
Well, show cause notice is previous.
Nothing is there.
Page 19, they have just.
It starts at page 15.
19.
Then facts of the case.
19.
Where there was an intent to evade payment of
The
tax.
matter came, yes, madam. The SSC, page 19 of your lordship's brief, the said SSC has evaded amount of duty on the full value of the industrial furnace manufactured and cleared by them by separately invoicing clearance of bought out items and manufactured items. The SSC had knowingly cleared manufactured items and bought out items separately. The value of the bought out items and manufactured items were included in the assessable value of the industrial furnace, as without the said items, the industrial furnace was non-functional. The customers were aware and also unconcerned about which goods will be manufactured by the SSC and which will be bought out from the market, because the customers did not pay any amount over and above the quoted lump sum contract amount. The matter came to the notice of the department on scrutiny of the documents records while conducting audit. Otherwise, the issue would remain unearthed. And since
Since the said SSC had suppressed the above mentioned component of value while making payments of duty and did not reflect the said material facts in the return submitted to the department with an intention to evade the payment of duty, the extended period of limitation for raising the due appears to be applicable in the instant case.
The allegation is the extended period, Lordship. They say because I have done the audit, and if I have not done the audit, this would not remain unearned. So, Lordship, my PL balance sheet, I am a company. I am regularly filing my excise returns also. Nothing. The tax evasion, Lordship, as held by Supreme Court in plethora of judgments, Univer Textile, that suppression has to be brought on record. But we were contesting, Lordship, on the ground of, and in the so-called reply also, Lordship, a detailed submission on the extended period was also given. But the tribunal, because held on the merits, that once it's an immovable property, it is a case of the department, it is brought out item. It is not the case that I am manufacturing it.
This is the furnace has to be assembled or in on site. You can't manufacture a furnace, bring and put it and fix it to the ground. It has to be that is why even if a factory is shifted, the furnace can't be dismantled. It has to be, if you try dismantling it, it will crumble.
It is sold as scrap in that case.
So in that
when
case,
it's scrapped,
it is scrapped.
the furnace part is scrapped. The machine parts may be opened, but the furnace gets scrapped, Lordship.
But there are several decisions on furnaces, cisterns.
And Lordship, the two judgments of the depth of the tribunal compilation went up to the Supreme Court, and Supreme Court has affirmed those.
Which two judgments?
Lordship, I'm just giving these two. I'm just mentioning the judgment.
Well, one has been admitted subject to correction of my learned friend. That is 2023-71 ELT 234. In the case of Chema Boilers versus Commissioner.
ও রেফারেন্সে আছে এই যে এটা অ্যাডমিট হয়েছে
Well, he has
Nicer India has been dismissed.
Nicer India and Lordship,
And
Kerala State Electronics.
Yes,
and Lordship, in Nicer India, they have recorded. Supreme Court has given a recording also. May I place it before Lordships?
Yes, yes.
The department revenue wanted to add the value of handle assembly, ball value assembly, overflow assembly, siphon assembly, outlet, flage assembly, and flush pipe assembly while arriving at the valuation of flushing concerns manufactured by the respondent. It is an admitted position that the aforesaid fittings are not manufactured by SSC. It is also an admitted position that the SSC supplied the same to those buyers only who had asked for that. In such a situation, the SSC buys the aforesaid components from market and supply. In this regard, the tribunal has rightly declined to add the value of aforesaid components. So, Lordship, it was also manufacturing at site.
It is a different context altogether.
What is, Lordship, to be taxed is 2F. When
this Nicer was followed in Transrail.
Translate, Lordship.
Transrail is in page 12 of that compilation.
Lordship, page 12.
Translate. এটাও ডিস্টিংগুইশেবল স্যার এই যে this is not
Well, it says it is optional. Where mere optional. Well, kindly see the heading. Where bought out items supplied. Well, kindly see page 12, the heading part of his compilation. Bought out items supplied by the appellant so and so, along with were neither used as parts nor were those accessories of lattice mast, as same was not required for manufacture of lattice mast. At most, bought out items were used for completing erection and installation.
Which is my case, Lord.
But over here,
same case.
High mast tower. So
and
it is
here
high mast.
also the high mast tower is permanently attached to the earth.
Yes, my lord, over here.
3.2, page 14.
Yes. Now the high mast bought out items were merely optional for customers to buy from appellant manual.
You have to bring out some evidence or some material to show that these items were part and parcel of the manufacture of the furnace. Unless and until you do
Well,
that.
that we cannot improve now. Well, we can only rely upon the adjudication order. Some of the portions of the adjudication order.
Manufacture of the furnace is a
complete product.
Is an independent issue. For the purpose of erection, there may be so many things.
Dunt bolts, various small items are also required.
The concrete.
Service is also required.
Which he doesn't manufacture. Admittedly, he doesn't. There's no evidence to show that it is also being manufactured in his factory. Admittedly, the items which were manufactured by him have suffered excise on removal from the factory.
Well, there is no evidence given by the SSC, nor there is any findings to that effect. It is
Furnace.
Yes, my lord.
Whatever he
The
has.
bought out items in rest of your lordship is
No,
agreed.
no. We are on the furnace. So whatever he has manufactured.
He has paid.
Central excise, it has suffered central excise. The onus is on the department to show that these items which now you are going to include in the accessible value of for the purpose of central excise were manufactured by him. When it's an admitted case that it was not manufactured.
It was not manufactured.
Then how do you include in the accessible value?
Well, we are saying that
Then you will have to include everything: transportation cost, head load workers, the fellow's salary, everything you include in the
2F,
accessible value.
that is what I was arguing. 2F, the concept of manufacture has been laid down in so many cases, Lordships.
My lord, we say that.
You read Mofatlal. Even 100 times you read,
yes,
you will get confused.
Well, that is why we are before your lordship, my lord. So that we come out of.
You have to read the judgment 5 pages a day. That's where you can assimilate. The first time when I became a standing counsel, that was the advice given by the senior judge of the division bench. He said, read Mofatlal. There was some vacation going on. The entire vacation you read Mofatlal. It helped me when facing super seniors appearing for the revenue. Definitely helped.
Supreme Court decision.
Well, that is the reason.
This Kerala State Electronic Development Corporation, that was also relied on in Translate.
And one judgment which my learned friend has referred, it has been the Supreme Court has.
Nicer India, they manufacture systems. This is furnace. There is nothing, not much of actual difference.
Chima boilers. This is the judgment. Chima boilers. Whatever, my lord, we could get, we are trying to assist your lordship.
That I have given you last day. That is why you have taken. Last day I have given my compilation to my learned friend.
So that we can also update ourselves.
Yes, yes.
It is a healthy practice of updating ourselves.
At times, the respondent is served. None appears for the respondent assessee. We admit your appeal.
Lordship.
Probably it's like this appeal filed by the revenue under section 35 capital G within bracket 1 of the Central Excise Act 1944 questions the correctness of the order dated 15th December 2023 passed by the Customs, Excise and Service Tax Appellate Tribunal, Kolkata, East Zonal Bench within bracket Tribunal in appeal number 75307 of 2017.
May I, my lord, sleep on?
The revenue has raised the following substantial questions of law.
My lord, I have formulated your lordship kindly this because there are
page number 10.
My lord, kindly refer this.
Oh, this one you want?
Yes, yes.
Not page 10, sir. The revenue has raised the following substantial questions of. No. So, though the revenue in the memo of appeal had raised certain substantial questions of law, the learned advocate appearing for the. At least you sign this. There is nothing at all. Some piece of paper. The learned counsel appearing for the appellant has handed over a fresh set of questions, substantial questions of law, and praise for considering the same. The questions of law suggested by the revenue are as hereunder. A. B. D. C not required. That's all. We have heard Bhaskar Prasad Banerjee, Tapan Banja. The appellant, sorry, sir. The respondent assessee filed the appeal before the tribunal, challenging the order in original dated 18/11/2016, passed by the Commissioner of Central Excise, Kolkata 2. In and by the said order, the proposal made in the show cause notice cum demand notice dated 22/5/2015 was affirmed, and interest was also directed to be recovered in terms of section 11 capital A of the Act, and penalty was also imposed under section 11 capital A capital C within bracket 1 of the Act. The question which fell for consideration before the learned tribunal was whether the bought out items, BOUGHT -out items, are includable in the assessable value of the industrial furnace. The department issued the show cause notice alleging that during the course of scrutiny of the documents and records while conducting an audit in the business premises of the assessee, it came to light that the assessee has not mentioned the components of value while making payments of duty and did not reflect the said materials in the return submitted to the department. This, according to the department, was with an intention to evade payment of duty, and therefore the extended period of limitation was also invoked. Personal hearing was afforded to the assessee pursuant to the issuance of show cause notice. The assessee's contention was that they entered into contract with different customers for design, fabrication, supply, erection, and commissioning of different furnaces, fume extraction systems, plants, etc. For such purpose, they manufactured and cleared parts of furnaces and handling equipment system and paid appropriate central excise duty in the stage in which those are cleared from the factory, that is, on the parts. The assessee further contended that the cost of bought out goods directly supplied to the buyer's place for erection and commissioning cannot be included in the assessable value. Further, the assessee contended that with the help of the manufactured goods on which duty was paid by the assessee and bought out items sent directly to the buyer's premises, the assessee undertook erection and commissioning of furnace and equipment handling system stage by stage by fixing those parts to the earth, which ultimately resulted in immovable property which ceases to be goods. Further, the assessee explained the type of activity done by them, and by pointing out that the furnaces and handling equipment system are assembled and erected at site and attached to foundation to earth, which cannot be dismantled without substantial damage to its components and thus cannot be reassembled. Therefore, items are not movable and hence not excisable goods. Further, the assessee submitted that industrial furnaces comes into existence by fixing various parts, stage by stage, to the earth, thereby rendering it an immovable structure which by any stretch of imagination cannot be called excisable goods. Therefore, the essentiality of the items used for erection and commissioning of such furnace for its functioning is not relevant at all in the case on hand. In the assessee's case. Further, with regard to the invocation of the extended period of limitation, the assessee contended that they relied upon several judicial pronouncements in support of their contention, and the entire issue is a matter of interpretation, and there was no deliberate attempt on the part of the assessee to evade payment of duty by resorting to suppression. Further, it was stated that if the issue is amenable to dual interpretation, longer period of limitation cannot be invoked. To support the contentions, the assessee relied upon various decisions. The adjudicating authority came to the conclusion that the assessee procured order for industrial finance and handling equipment system in complete form so that it can start functioning. Therefore, the bought out items on which duty has not been paid is essential ingredient for completion of the machine, that is for fulfillment of the orders procured by the assessee. Therefore, the adjudicating authority came to the conclusion that the value of the bought out items is includable and sustained the proposal in the show cause notice. After making certain observations on the decisions which were relied on by the assessee, the adjudicating authority proceeded to confirm the demand made in the show cause notice. As pointed out earlier, the issue which fell for consideration before the tribunal, learned tribunal, as well as this court, is whether the value of the bought out items supplied directly to the customer's place are includable in the assessable value of industrial furnaces. The tribunal has referred to various decisions, and one such of the coordinate bench of the tribunal, and one such decision being in the case of Transrail Lighting Limited versus Commission of Central Excise and Service Tax, Silvasa, SILVASA, 2023 710 Centax 185 within bracket TRI full stop hyphen AHMD, short form of Ahmedabad, bracket close. It is in page 12 of the compilations. In the said decision, several decisions were relied upon, and it will be beneficial to point out two such decisions, the first of which being in the case of NEYCER, NEYCER India Limited versus CCE 2005 192 ELT 620 within bracket Tribunal Chennai, which was affirmed by the Honorable Supreme Court in CCE versus NEYCER India Limited 2015 320 ELT 28 within bracket SC. In this compilation, you have included nicer.
Lordships, yes.
Huh?
That is at page number
A2, page number not given.
80. No, page number 20.
The index you have not given.
No, index notice we had given, but page numbering was not mentioned in the index.
That is it.
Yes, not sure. It was actually printed again for this matter. That is why. In the sestet we had given page 20. Lordships.
In Nicer India Limited, the learned tribunal relied upon the decision of the High Court of Bombay in Coron Business Systems Limited, KORON, versus Union of India, 1992 58 ELT 48 within bracket Bombay. And it was pointed out that the bought out items required to make the cistern functional a system, all right, comma, should be considered as accessories only. Semicolon, these accessories are different types and made of different material. Semicolon. At the buyer's option, these are supplied by parts, should be included. These are supplied by the parts should be included in the accessible value of the system. The appellant therein relied on the decision of the Honorable Supreme Court in Union of India versus Coron Business System Limited, 1997-93 ELT 663, which upheld the judgment of the Bombay High Court. In the judgment of the Bombay High Court, it was held that plates and black shields are required for the working of photocopier, but that by no stretch of imagination leads to the conclusion that plates and black shields are part and parcel of the machine and therefore cannot be included in the value of the photocopiers. The tribunal also relied upon various other decisions and ultimately allowed the assessee's appeal. The revenue challenged the order passed by the tribunal before the Honorable Supreme Court, which was dismissed as reported, dismissed, in Commission of Central Excise, Trichy versus Nicer India Limited, 2015 320 ELT 28 within bracket AC. The Honorable Supreme Court in the said case held, the Honorable Supreme Court in the said case noted that the revenue wanted to add the value of handle assembly, ball valve assembly, overflow assembly, etc., while arriving at the valuation of flushing cisterns manufactured by the assessee therein. It was held that it being an admitted position that those fittings are not manufactured by the assessee, and it is also an admitted position that the assessee therein supplied the same to those buyers only who asked for that, and in such a situation, the assessee buys the aforesaid components from the market and supply to the buyers at their option, and therefore the Honorable Supreme Court upheld the decision of the tribunal, which declined to add the value of the aforesaid components, which are not the part of flushing cistern manufactured by the assessee. And with this observed finding, the appeal was dismissed. The other decision which was relied on by the tribunal in the case of Transrail Lighting Limited was the case of, one second. Is in the case of Kerala State Electronic Development Corporation versus CCE, Trivandrum, 2008 224 ELT 88 within bracket TRI Bangalore bracket close. In the said decision, it was held that the value of bought out items cannot be included in the assessable value of machinery. The decision of in the case of Commissioner versus Kerala State Electronic Development Corporation was affirmed by the Honorable Supreme Court as reported in 2006 within bracket 199 ELT A 130 within bracket SC. What is this Godrej boys? That is 11 AC penalty, is it?
Lordship, that is for penalty extended period. Lordship, in the synopsis in page number in our compilation, Lordships, page number 8 onwards, we had given the about the extended period in our compilation.
In the impugned order, the tribunal has taken note of the decision in Transrail Lighting Limited as well as Nicer India, which judgment was affirmed by the Honorable Supreme Court as mentioned above. The tribunal then proceeded to examine the facts which were not in dispute and held that erection of the furnace, after the erection of the furnace, the bought out items are part of the immovable property and therefore held that they are not includable in the assessable value for the purpose of charging central excise duty. Thus, we are of the view that the learned tribunal rightly applied the legal principle and granted relief to the assessee, and the impugned order does not call for interference. What is this small compilation you have given?
My lord, we have given, my lord.
Oh, that is. Before that one paragraph, before last. The learned senior standing counsel for the appellant placed reliance on the decision of the Honorable Supreme Court in the case of MIL India Limited versus Commission of Central Excise Noida, 2007 10 SC 10 ELT 188 within bracket SC. In the said decision, correct. In the said decision, the department's contention, in the said case, the department's contention was the bought out items were necessary for the manufacture of plant at site, which was erected and assembled by the two companies through their contractors. It was pointed out by the Honorable Supreme Court that the question whether the value of bought out items should be added for computing the assessable value would depend on facts of each case. Thus, on facts, the tribunal has found that the bought out items are supplied directly to the customer's place and they get embedded to earth and they are not immovable, they are immovable property, and the question of including the value in the assessable value for the purpose of demanding central excise duty would not arise. Appeal is dismissed and the substantial questions of law are answered against the revenue.
Sir, it's a 95 days delay in the
She was in the same chamber before she got selected. So, her husband is also a lawyer, counsel. She was immediately paid a very
Item number 8.
My lord, I am for the appellant. My lord, kindly condone the delay and fix the matter for another day, my lord, for admission.
My lord, Sharaf is the object.
No, no, my lord, I am not objecting, my lord, with respect to the delay part.
Rather, we are.
That is your discretion, my lord, absolute discretion. I am not going into. My lord, I have a preliminary objection with respect to maintainability because, my lord, the issue is of classification, my lord, and which lies before the Honorable Supreme Court, my lord. That maintainability issue is there, my lord. My lord, kindly refer to page 50 of their, my lord, stay application, my
My
lord.
lord, kindly takes up the admissibility of this appeal, my lord,
second,
on
sir,
another day, my lord.
Page 50, my lord, of their, my lord, stay application. Para 4.2, at the outset, I take up the issue of classification.
See, we can't, truncate or bifurcate that issue from the other issues. We have already held. In Code 16 also we were there. If one issue relates to classification, lock, stock and barrel, you have to go there. We'll condone the delay. So on, so on, so delay condone. Para. This appeal has been filed by the revenue under section 35G of the Central Excise. Anjani, give the Central Excise Act. 35G of the Central Excise Act 1944, read with section 83 of the Finance Act, challenging the order dated 4/3/2024, passed by the Customs Excise Service Tax Appellate Tribunal, Calcutta, within bracket tribunal in Service Tax Appeal number 71181 of 2013.
But my lord, tribunal does not, my lord, touch that point.
No, my lord, that is the point, paragraph 2.1, my lord, of the tribunal's order, my lord. Kindly refer to paragraph 2.1. That is the issue framed by the tribunal.
Has raised the following substantial questions of law, page 13 and 14, 1 to 4. The core issue which was decided in the instant case by the adjudicating authority is with regard to the classification. The show cause notice issued to the assessee proposed that the services provided by them as business support service. The assessee contested the show cause notice. However, the adjudicating authority, by order dated 24/6/13, confirmed the proposal in the show cause notice, which was challenged before the tribunal, and the tribunal was, and the assessee was successful before the tribunal. If the matter pertains to a classification issue, then in terms of section
35G, my lord.
35G.
35G.
35H.
L.
No, 35G. 35.
G is appeal.
Supreme Court appeal.
Supreme Court
For
appeal.
Supreme Court,
35A,
the appeal goes to
35A, man.
35L, but the classification issue cannot be decided by the High Court. That is there in the 35G only.
করতে পারবে
whole section. You come to 35G. Appeal to the High Court. 1. An appeal shall lie to the High Court from every order passed in an appeal by the appellate tribunal on or after the first day of July 20, not being an order relating, among other things, to the determination of any question having a relation to the rate of duty of excise or value of goods to the purpose of assessment. So this, for that, directly an appeal lies to the
business support.
that is the provision. Then come to 35L, page 89. Since this issue, since the core issue to be decided relates to classification, which will have a direct relationship to the rate of service tax payable, right? In terms of the section 35L, appeal lies to the tribunal. Therefore, the appeal stands disposed of on the said ground, leaving it open to the revenue to file the appeal before the Honorable Supreme Court if they are so advised. Have you filed the original?
Yes, madam. Liberty may be given to take back
The
that.
registry is directed to return the original, the certified copy of the impugned order passed by the learned tribunal to the learned advocate appearing for the appellant revenue after retaining a photostat copy of the same.
Great.
তারপরে কি করবে?
60 days delay আছে।
KG on a substance.
কি আছে?
Classification.
এই তো। আচ্ছা, দিল্লিটা কোন?
Item number 9.
My lord, I am for the appellant, my lord, there is delay of 60 days, my lord.
Judgment পরের দিন judgment during judgment.
Well, I want to, my lord, rely upon certain judgments. Today we don't have the hand of that judgment. Well, I think, well, this matter will go on. The GTEX matter. That's why I couldn't bring that. Kindly takes up on admission or any other day, my lord. This matter relating to my refund, my lord. My lord, even after judgment passed in 2015, he filed in 2018. Well, if I, my lord, if your lordship sees, my lord, section 27, 1 capital B sub small b, then my lord, that will have to made within a year. He waited
lord,
for 2.5 years and come with this application. Even the judgment pronounced by the Supreme Court, my lord.
My lord, we received the brief yesterday evening only, my lord. Therefore, we are praying to take the admission hearing on some other day, your lords.
পার হয়ে গেল 14 তে।
But the commissioner and the tribunal record that the duty was paid under protest.
Yes, well, mere protest does not survive him to fulfill the statutory obligation.
Then
the self-assessment is also appealable unless it is modified by the appeal, my lord. He cannot simplicity say I am made on protest. That will not survive his case, my lord, unless he
delay is condoned. You mark her appearance. List the appeal.
well, similar the next matter of the same issue, my lord.
Same issue.
Different period.
Item number 10.
Same, my lord.
Item 10, same.
Item number 11.
Well, same order in item number 10 also.
Yes, Malad 11, I appear for the appellant.
Lordship, I am appearing for the Kolkata Municipal Corporation. I have already filed my report. From the last order, it appears that there was a direction upon the fire department to file a report, Lordship.
Yes, my lord. This is the report, my lord. My lord, may the report of the fire department be circulated so that we also, my lord, get a chance to go through it. Yes. Issue was regarding, my lord, installation of fire safety, my lord, appliances in a, my lord, building at Russell Street. And lordship was, my lord, kind enough to pass, my lord, an order for the corporation to first inspect and thereafter file a report. That report was filed and fire department was also called upon to file a report. This is possibly coming today, my lord.
My lord, I appear for the respondent number 5. Lordship, I have filed the exception to the report filed by the Kolkata Municipal Corporation. I have already filed it.
Where is the fire department report?
Yes, yes, ma'am.
Copy them.
এটা এই মুহূর্তে আমি দিয়ে দেবো সব ঠিক আছে এক্সট্রা কপি নেই এখন দিয়ে দেবো আমি মনে করি আমাদের সার্ভিস করেছি কারণ আমি তো এই ম্যাটারে ছিলাম না তখন আর সুশান আছে
6 months time has been given, madam, to comply with the defects. We can't wait till the fire occurs. Maybe according to you, 1974 the building was constructed. Assessment to property tax is only in 1996-97. Please consider about the people who are living in the building. If they are willing to get charged because of a fire accident, let them do so. But the people around in that locality. Now, on an average, at least we have 2 fire accidents in Kolkata every month.
My lord, the adjacent building to this property, my lord, recently, my lord, caught fire. And it was, my lord, there in the news.
What is that mall? Big mall. And that famous shopping mall, it was closed for almost 30 days because of a huge fire accident.
Explained everything in my lord, the
There
entire
are
responsibility was handed over to the association who is not appearing. Respondent number 3.
5.
My lord, no, I am for the
No, no.
association. The association form.
You are appearing for?
I am appearing for the
Builder.
builders. And my
But
lord,
you have got no control over the property.
recently, but in 2020.
Where is your report? Your whole,
Lordship, I have it.
this one.
Yes.
In which paragraph you stated?
Explained everything, my lord. Since, my lord, February 2020, my lord, I have handed over the entire responsibility to the Kanchana Building Apartment Owners Association. Lordship, kindly see, sir.
So you have got no control over the building.
Now, my lord, I have no control. My lord,
Now who appears for the association?
my lord, I do not know,
My lord, possibly this is not correct because my grievance, I was the writ petitioner before the learned single judge. My grievance was against, my lord, the authorities as well as the, my lord, developer. Because it's, my lord, under the Corporation Act, my lord, an application is to be made for fire safety clearance first before somebody can apply, the developer can apply for completion certificate. My lord, so fire safety clearance comes first. Once that is obtained, with that, my lord, you apply before the corporation for getting a completion certificate, either a partial completion certificate or a complete, my lord, certificate. Now, the developer fails to do so. Now, the developer is trying to, my lord, shift the buck on the, my lord, association.
As per the report, please give them copies.
Can we get a copy of the fire?
7 deviations. Share one copy, or we will share and give you one copy.
7 deviations there.
Third paragraph, it is revealed from the record building authority of the building question applied for fire safety certificate 3 times. First 2 times so and so was auto rejected by the system on the of delayed action by citizen. Third application placed before technical expert committee. Evaluation scrutiny report inspector earlier approved plan drawing recommendations etc. Observed that some deviations have been detected, recommended for rejection of the fire safety certificate.
This, my lord, 13th of February, we have, my lord. I have disclosed also in the writ petition.
Collapsible gate in one lift, inadequate capacity,
2017.
mechanical smoke extraction, fire refuge area, sprinkler in all 4. Reason for rejection communicated to the concerned applicant Suresh Mohonto. Not. Who's that person? Your client? Suresh?
No, my lord, he is the secretary of the
Association.
I am not the association. My lord.
It's clear the concerned building authority so has not complied with the fire deviation so and so. In compliance with the order, it has been requested to the occupiers, owners, Kanchana apartment owners to comply with the fire safety measures given earlier and remove the deviations within 6 months from there. You assist them in removing at their cost. See,
I have so far, my lord, I have assisted, my lord, I have explained everything, how whatever duties had to be done.
Where is your completion certificate?
The completion certificate is not there, my lord.
So
Give it, my lord, please.
therefore, you can't wash your hands on it.
Yes, my lord.
So
I
the
know.
nemesis will continue.
But now, my lord, since 2020, my lord, for 5 years, I am not in the charge of anything, my lord.
Maybe.
My lord,
If you have not given the completion certificate, the owners will latch on to you.
completion certificate.
We will give you time to comply with this order. We will record today that you cannot run away from or shirk your responsibility.
Very grateful, my lord.
Lordship, I understand that, my lord, but for this, my lord, fire safety.
See,
this, my lord,
it is not very. It is not very.
It's not sent to buy the
Fire safety device not provided. Probably extinguishers have to be provided. Now, as per the what is that enactment which governs the lift act or something is there.
The second lift was already done.
Yes, there is an act.
So collapsible gate is not permissible.
Yes, my lord, that was there. Where from
No, heritage building it is permissible.
my lord, this is not
Inadequate over a triangle reservoir, etc. Easily you can do. How many floors is building?
15.
My lord, 15 floors. 15 floors.
Probably 3 crores it may.
With a
cost.
basement.
With the basement.
With the basement, yes.
Plus ground floor plus 15.
Probably 5 crores.
And it's a high-risk building, my lord, under the act.
And what happened to your writ petition? Dismissed.
My writ petition was dismissed on the ground that it's a private cause of action against the developer. Because, my lord, what was happening is, I was being treated as an occupier, though my specific case is I am not in occupation, till such time there is a completion certificate. Now, my lord, the learned single judge...
That IAS officer staying elsewhere, that is.
Yes.
Waiting for the building to catch
Waiting
fire.
for the... Not to catch fire, but for, my lord, the developer cannot shirk off the responsibilities which are
All right.
statutorily mandated.
We have heard the learned advocates for the parties.
My lord, may I submit?
No,
one
we
thing?
will not pass any order. We'll.
My lord, only one thing, my lord. My lord, the last annexure of my report kindly sees, my lord. Last page 17.
A copy there.
Page 17.
Yes, my lord.
You have got a copy.
Lordship, this letter is written to my lord, the petitioners, the appellants. My lord, it is written in December 2019. My lord, the appellant himself is, my lord, not paying the amount which is payable for fire safety. Entire, my lord.
All right. No, you comply with that. Your client let them pay.
This is 10 lakhs. I have, my lord,
10 lakhs 87,940.
2019. And since then, my lord, he is not paying anything.
You comply with it, they will also pay.
But if whatever in my hands, my lord, I am ready to comply, cooperate with the present association. Nothing is now, my lord, in my
What
hands.
is the name? Sanjeev Sanyal and
They are the
Saurav
appellants,
Sanyal.
They are two, my lord, flat owners
So
of
you
the
pay
building.
this money.
My lord, I really don't know whether this is, my lord, on what account this is being demanded, but if there is anything outstanding legally, my lord, we will definitely do that. But my lord, the developer should, my lord, take responsibility of installation of the firefighting system. My lord, this, my lord, money which is being demanded, I will definitely take instructions from my client on what account, my lord, the developer is demanding this. Because according to us, everything that was due and payable to the developer has been paid.
My lord, I have, my lord, introduced, my lord, the present secretary, president, everyone to the Director General, West Bengal Fire and Emergency.
See, the developer writes to all of you, see page 17, para 1.
Yes, my lord.
So and so regarding your Kanchana building, last 2 lines. Flat number 10B, 10A, 11A
Yes.
is paid. It will help in completing the remaining work of fire safety.
Yes.
So therefore, they agree to do it. So your cooperation is also the best interest of all safeguarding the property.
My lord, not only that, this is a my lord, problem with the building. My lord, in 1995 even, there is a resolution, lordship kindly comes to page 13. My lord, this is an age-old problem with the building. My lord, nobody wants to give the payment. For no.
You might not have occupied the building, but maintenance charges you have to pay.
My lord, I also don't know, my lord, whether
In terms of the directions issued, the Director, West Bengal Fire and Emergency Services, has filed a report, which is taken on record. Let copies be served on the learned advocates for the parties. On going through the report, it is seen that there are several defects which have been pointed out by the technical expert committee, and time has been granted for a period of 6 months to rectify the defects and apply for fire safety certificate. The builder has filed an exception to the report filed on behalf of the 5th respondent, wherein among other things it is pointed out that the writ petitioners are defaulters in as much as they have not paid the monthly services and maintenance for the periods as indicated in the letter dated 6th December 2019. The writ petitioner is directed to show cause as to why a direction should not be issued to them to pay the amount demanded by the said letter to the tune of rupees 10,87,940. It is to full stop. It is to be noted that in the said letter, the builder has stated that payment of the amount will help in completing the remaining work of fire safety. This would indicate that the builder is willing to undertake to complete the fire safety work and secure the license. All the more, since completion certificate is yet to be issued in favor of the builder cannot shirk its responsibility nor contend that it is the responsibility of the association to take care of the fire safety norms. Therefore, full stop. Liberty is granted to the parties to file exception to the report submitted by the West Bengal Fire and Emergency Services. List the matter after 2 weeks, sir, under the same caption.
Grateful, my lord.
Grateful, my lord.
We'll stop.
My lord, if anything is due and payable, we'll definitely do that, my lord.
You ask them.
Lordship has provided for an opportunity to show cause, but if something is due, we will definitely, my lord.
Pay. You ask them to pay. We have recorded that
Yes,
they will
yes,
undertake.
yes.
They can't shirk their.
Grateful, my lord.
My lord, item 66, my lord, may I request, my lord, to keep it high on the board, my lord, on the next date, Friday.
66, if you want to withdraw, we will do it. No higher on the. Slowly.
The difficulty is, my lord, that they have issued one notice of hearing, my lord. It was remanded back to the authority.
See what can be done. What is next matter? AP 126. You are for 12.
But I am appearing virtually, my lord, for the appellant. So in this matter, as per your lordship's last order, an inspection was directed to be held on 15th. Lord, the CESC has done so. They have inspected, but unfortunately, my lord, the petitioner was suffering ailments because of pancreatitis. He could not be present. However, my lord, if they chose to file a report, let that be circulated, my lord. I'll come back with instructions to that effect.
Report is ready.
My report is ready, and your lordship will find the. May I submit subject to lordship approval or?
No, we will give copies of the report.
Lordship.
My lord, on the private respondent also, your lordship.
May the report be
Mr.
filed.
Banerjee, is any of your colleague in the courtroom?
clerk,
the private
clerk
respondent
is present here, my lord. I will get in touch with him. I will take it.
All right.
I will get in
The
touch with the
report
person. I will
filed
take it.
by the CESC Limited is taken on record. Let
My
copies.
report in the form of affidavit. Lord.
Affidavit. Let copies of the same be served on the learned advocates for the parties. Liberty to file exception if they so desire. After 2
Grateful,
weeks. Next.
Deeply obliged.
Item number 13.
With 13, I appear on behalf of the petitioner, my lord. I'm being led by Mr. Bikash Ranjan Bhattacharya in this matter, my lord. This is that matter relating to, my lord, there was an office space which was being used by the petitioner.
Yes,
I was told.
Yes, your lordship, there was a
inspection,
joint
your
inspection
lordship,
was supposed to be held,
I'm
my lord.
told one of the state representative had requested for some time for the
Yes.
inspection. The inspection could not take place. Lordship will keep it after 1 week or 10 days, my lord. I
Lord
think.
direct fixes a date, then all
By
parties
order
can go.
dated so and so. Ulindra, her name, I forget her name.
Inspection is date fixed.
Last order uploaded.
I appear for the app.
তুমি আমায় পাঠিয়ে দিচ্ছিলে
The order sheet you give.
And in this matter, there is no.
One reason. I always say
order হয়নি বলতে
But there was no order which was specifically made by your lordship. Your lordship desire was that both the advocates
orally
and that this is the term. And we have taken photographs in terms of your lordship's direction. Photographs of the premises in question, how far it is. The banquet is running at the instance of a private entrepreneur. And they are seeking to this is the
which area this is? Maniktal.
This is Maniktal, your lordship, because Kakurgachi rail bridge.
Kakurgachi.
Left side of the rail.
একটা কপি আমাদের কাছে
আমারও দাও
তোমাকে কিছু দেব
Radhe Krishna banquets.
Yes, Radha Krishna Bank. This is running and at the instance of this.
Who's running Mr. Sen's?
No. Mr. Sen is
I don't want to be on the top
also
of
a
this.
saloon. Rascal
Yes.
Saloon. Lovely.
So these things are running.
Not depot, their office. Where is your office?
My office is on the third floor. In the first floor, this is the portion occupied by me. How portion occupied? Which is my portion?
This blue area is what they want to have the tram office.
The entire.
The Transport Corporation.
Transport Corporation, seeks my area, which is my area is an occupation is approximately 2,500 square feet. I'll hand over.
Let us come back with the inspection, my lord.
Yes.
And let us, what I was just requesting to my lords, subject to your lordship's very gracious convenience, since it fell from the Honorable the Chief Justice, let all of us, agree to a particular date.
Yes, বলো না কবে
বলো তুমি বলো
স্টেটের অ্যাডভোকেট কে লাগবে আমি তো
জুনিয়র কে ও তুমি কি আচ্ছা
স্টেট লাগবে
where is the state?
It is a ground plus 1 floor building. G plus 1.
G plus 2.
G plus 2. G plus 2.
We are only in occupation of the
existing ground floor. There is a banquet. There is a saloon. Adhunik
basement is also the banquet.
And the rear area is occupied by the kitchen, and the front area is occupied by the basement entry, banquet entry for basement, common passage, gone. Then this
the
is
first floor, a portion is occupied by us.
And the remaining is banquet office area.
Yes.
Directorate of Youth Services. Youth Services is not running
No,
banquet.
Youth Services has left.
No, this map shows, plan shows, banquet office area, Directorate of Youth Service.
I don't know whether this is prepared by them, but Directorate Youth Service by letter they have handed over possession.
Request of the learned
Let the joint inspection
Yes,
on any day.
2 weeks.
With the state advocate.
Your date.
Joint inspection date টা fix করো।
State advocate লাগবে তবে তো ready.
তুমি রাজি হও না আমরা স্টেট কে বলবো। বলো তুমি বলো next Saturday.
হ্যাঁ।
Subject to your lordship's next Saturday. Next Saturday. The following day.
Subject to state advocate.
You let the
state representative has to be there.
Before my lord, they will say that they are going to sit. My learned friend is too busy.
No, no,
No,
that's
my
not a
lord.
question of we being busy.
I'm not blaming anyone, my lord.
The state is not, advocate is
The
not.
state advocate is also not represented, my lord.
We have
So the-
listened to
Let
them.
the state advocate be present.
Who appeared the other day?
You know, Mrs. Sonal Sinha. I am told today, you know, I am told by her that the senior standing counsel, government of West Bengal, is likely to appear in the matter, but he is not there, of course. But that is, of course, you know, orally she has informed.
Shirshan was here. Bandyopadhyay was here.
Sonal, no, Shirshan.
He was here.
Shirshan Bandyopadhyay.
He was here.
Sitting here with his iPad.
they could not apprehend, my lord, the matter will be taken up.
You know, let the inspection, 9th March.
8th March.
We will not win there.
Very
Absent
good.
of
The
the
lordship
fixed
has said after a fortnight, the inspection will be done
You
within
tell
that time.
that, you tell
Yes,
Sonal
inspection
that
will be done within that time.
inspection to be done, or you tell Mr.
The
Bandyopadhyay
matter is returnable 3 weeks.
2 weeks.
2 weeks.
Within that, let them
In
complete.
Very
inspection.
great. What a great. No.